The Constitution of India. We, the people of India, having solemnly resolved to constitute India into a one, sovereign socialist secular democratic republic, and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the two, unity and integrity of the nation. In our Constituent Assembly this 26th day of November, 1949, do hereby adopt, enact and give to ourselves this Constitution. 1 subs. By the Constitution, 42nd Amendment, Act, 1976, s. 2, 4, Sovereign Democratic Republic W.E.F. The 1st of March 1977. 2 subs. By s. 2, Ibid. 4, Unity of the Nation, W.E.F. The 1st of March 1977. Preamble. Part 1. The Union and its Territory. 1. India, that is Bharat, shall be a union of states. 1. 2. The states and the territories thereof shall be as specified in the first schedule. 3. The territory of India shall comprise, a. the territories of the states. 2. B. The Union territories specified in the first schedule, and c. such other territories as may be acquired. 2. Parliament may by law admit into the Union, or establish, new states on such terms and conditions as it thinks fit. 3. 2a. Sikkim to be associated with the Union, representative, by the Constitution, 36th Amendment, Act, 1975, s. 5 W.E.F. The 26th of April 1975. 3. Parliament may by law, a. form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state. b. Increase the area of any state. c. Diminish the area of any state. d. Alter the boundaries of any state. e. Alter the name of any state. 4. Provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President and unless, where the proposal contained in the bill affects the area, boundaries, name and territory of the Union, admission or establishment of new states, formation of new states and alteration of areas, boundaries or names of existing states. 1 subs. By the Constitution, 7th Amendment, Act, 1956, s. 2, for cl. 2. 2 subs. By s. 2, Ibid. For subclause b. 3. Article 2a was ins. By the Constitution, 35th Amendment, Act, 1974, s. 2, W.E.F. The 3rd of January 1975. 4 subs. By the Constitution, 5th Amendment, Act, 1955, s. 2, for the proviso. 2. Or name of any of the states. 1 The bill has been referred by the President to the legislature of that state for expressing its views thereon within such period as may be specified in the reference or within such further period as the President may allow and the period so specified or allowed has expired. 2. Explanation I. In this article, in clauses A to E, state includes a Union territory, but in the proviso, state does not include a Union territory. Explanation 2. The power conferred on Parliament by Clause A includes the power to form a new state or Union territory by uniting a part of any state or Union territory to any other state or Union territory. 4. 1. Any law referred to in Article 2 or Article 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule as may be necessary to give effect to the provisions of the law and may also contain such supplemental, incidental and consequential provisions, including provisions as to representation in Parliament and in the legislature or legislatures of the state or states affected by such law as Parliament may deem necessary. 2. No such law as aforesaid shall be deemed to be an amendment of this Constitution for the purposes of Article 368. Part 1. The Union and its Territory, Arts. 3-4. Laws made under Articles 2 and 3 to provide for the amendment of the first and the fourth schedules and supplemental, incidental and consequential matters. 1. The words and letters specified in Part A or Part B of the first schedule, omitted by The Constitution, 7th Amendment, Act, 1956, S. 29 and sch. 2 ins. By the Constitution, 18th Amendment, Act, 1966, S. 2. Part 2. Citizenship. 5. At the commencement of this Constitution, every person who has his domicile in the territory of India and a. who was born in the territory of India, or b. either of whose parents was born in the territory of India, or c. who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement, shall be a citizen of India. 6. Notwithstanding anything in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of this Constitution if a. he or either of his parents or any of his grandparents was born in India as defined in the Government of India Act, 1935, as originally enacted, and b. in the case where such person has so migrated before the 19th day of July, 1948, he has been ordinarily resident in the territory of India since the date of his migration, or e. in the case where such person has so migrated on or after the 19th day of July, 1948, he has been registered as a citizen of India by an officer appointed in that behalf by the Government of the Dominion of India on an application made by him therefore to such officer before the commencement of this Constitution in the form and manner prescribed by that Government, provided that no person shall be so registered unless he has been resident in the territory of India for at least 6 months immediately preceding the date of his application. Citizenship at the commencement of the Constitution. Rights of citizenship of certain persons who have migrated to India from Pakistan. 4. 7. Notwithstanding anything in Articles 5 and 6, a person who has after the 1st day of March, 1947, migrated from the territory of India to the territory now included in Pakistan shall not be deemed to be a citizen of India, provided that nothing in this article shall apply to a person who, after having so migrated to the territory now included in Pakistan, has returned to the territory of India under a permit for resettlement or permanent return issued by or under the authority of any law, and every such person shall for the purposes of Clause B of Article 6 be deemed to have migrated to the territory of India after the 19th day of July, 1948. 8. Notwithstanding anything in Article 5, any person who or either of whose parents or any of whose grandparents was born in India as defined in the Government of India Act, 1935, as originally enacted, and who is ordinarily residing in any country outside India as so defined shall be deemed to be a citizen of India if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country where he is for the time being residing on an application made by him therefore to such diplomatic or consular representative, whether before or after the commencement of this Constitution, in the form and manner prescribed by the Government of the Dominion of India or the Government of India. 9. No person shall be a citizen of India by virtue of Article 5, or be deemed to be a citizen of India by virtue of Article 6 or Article 8, if he has voluntarily acquired the citizenship of any foreign state. 10. Every person who is or is deemed to be a citizen of India under any of the foregoing provisions of this part shall, subject to the provisions of any law that may be made by Parliament, continue to be such citizen. 11. Nothing in the foregoing provisions of this part shall derogate from the power of Parliament to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Part 2, Citizenship, Arts. 7, 11. Rights of citizenship of certain persons of Indian origin residing outside India. Rights of citizenship of certain migrants to Pakistan. Persons voluntarily acquiring citizenship of a foreign state not to be citizens. Continuance of the rights of citizenship. Parliament to regulate the right of citizenship by law. Part 3. Fundamental Rights. General 12. In this part, unless the context otherwise requires, the state includes the Government and Parliament of India and the Government and the legislature of each of the states and all local or other authorities within the territory of India or under the control of the Government of India. 13. 1. All laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. 2. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. 3. In this article, unless the context otherwise requires. A. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage having in the territory of India the force of law. B. Laws in force includes laws passed or made by a legislature or other competent authority in the territory of India before the commencement of this Constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. 1.4. Nothing in this article shall apply to any amendment of this Constitution made under Article 368. Right to equality. 14. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Definition. Laws inconsistent with or in derogation of the fundamental rights. 6. Equality before law. 1. Ends. By the Constitution, 24th Amendment, Act, 1971, S. 2. 15. 1. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth or any of them. 2. No citizen shall, on grounds only of religion, race, caste, sex, place of birth or any of them, be subject to any disability, liability, restriction or condition with regard to a. Access to shops, public restaurants, hotels and places of public entertainment, or b. The use of wells, tanks, bathing ghats, roads and places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. 3. Nothing in this article shall prevent the state from making any special provision for women and children. 1.4. Nothing in this article or in Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. 2.5. Nothing in this article or in subclause G of Clause 1 of Article 19 shall prevent the state from making any special provision, by law, for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes or the scheduled tribes insofar as such special provisions relate to their admission to educational institutions including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in Clause 1 of Article 30. 16. 1. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. 2. No citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence or any of them, be ineligible for, or discriminated against in respect of, any employment or office under the state. 3. Nothing in this article shall prevent Parliament from making any law prescribing, in regard to a class or classes of employment or appointment to an office. Part 3, Fundamental Rights, Arts. 15-16. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Equality of opportunity in matters of public employment. 1. Added by the Constitution, First Amendment, Act, 1951, S. 2. 2. Ends. By the Constitution, 93rd Amendment, Act, 2005, S. 2, W, E, F. The 20th of January 2006. 1. Under the government of, or any local or other authority within, a state or union territory, any requirement as to residence within that state or union territory prior to such employment or appointment. 4. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens which, in the opinion of the state, is not adequately represented in the services under the state. 2. 4a. Nothing in this article shall prevent the state from making any provision for reservation 3, in matters of promotion, with consequential seniority, to any class, or classes of posts in the services under the state in favor of the scheduled castes and the scheduled tribes which, in the opinion of the state, are not adequately represented in the services under the state. 4.4b. Nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year in accordance with any provision for reservation made under Clause 4 or Clause 4a, as a separate class of vacancies to be filled up in any succeeding year or years, and such class of vacancies shall not be considered together with the vacancies of the year in which they are being filled up for determining the ceiling of 50%. Reservation on total number of vacancies of that year. 5. Nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. 17. Untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. 18. 1. No title, not being a military or academic distinction, shall be conferred by the state. 2. No citizen of India shall accept any title from any foreign state. Part 3. Fundamental Rights, Arts. 16, 18. 1. Subs. By the Constitution, 7th Amendment, Act, 1956, S. 29 and SCH 4, under any state specified in the first schedule or any local or other authority within its territory, any requirement as to residence within that state. 2. Ins. By the Constitution, 77th Amendment, Act, 1995, S. 2. 3. Subs. By the Constitution, 85th Amendment, Act, 2001, S. 2. For certain words. W. E. F. The 17th of June 1995. 4. Ins. By the Constitution, 81st Amendment, Act, 2000, S. 2. W. E. F. The 6th of September 2000. Abolition of untouchability. Abolition of titles. Part 3. Fundamental Rights, Arts. 18-19. 3. No person who is not a citizen of India shall, while he holds any office of profit or trust under the state, accept without the consent of the President any title from any foreign state. 4. No person holding any office of profit or trust under the state shall, without the consent of the President, accept any present, emolument, or office of any kind from or under any foreign state. Right to freedom. 19. 1. All citizens shall have the right, a. to freedom of speech and expression, b. to assemble peaceably and without arms, c. to form associations or unions, d. to move freely throughout the territory of India, e. to reside and settle in any part of the territory of India, 1, and 2. G. to practice any profession, or to carry on any occupation, trade or business. 3. 2. Nothing in subclause A of Clause 1 shall affect the operation of any existing law or prevent the state from making any law, in so far as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interests of 4. The sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. 3. Nothing in subclause B of the said clause shall affect the operation of any existing law in so far as it imposes, or prevent the state from making any law imposing, in the interests of 4. The sovereignty and integrity of India or public order, reasonable restrictions on the exercise of the right conferred by the said subclause. 4. Nothing in subclause C of the said clause shall affect the operation of any existing law in so far as it imposes, or prevent the state from making any law imposing, in the interests of 4. The sovereignty and protection of certain rights regarding freedom of speech, etc. 1. Ins. By the Constitution, 44th Amendment, Act, 1978, S. 2. W. E. F. The 20th of June 1979. 2. Subclause F, omitted by S. 2. Ibid. W. E. F. the 20th of June 1979. 3 subs. By the Constitution, First Amendment, Act, 1951, s. 3, for cl. 2, with retrospective effect. 4 ins. By the Constitution, 16th Amendment, Act, 1963, s. 2. Integrity of India or public order or morality, reasonable restrictions on the exercise of the right conferred by the said subclause. 5 nothing in 1, subclauses D and E of the said clause shall affect the operation of any existing law in so far as it imposes, or prevent the state from making any law imposing reasonable restrictions on the exercise of any of the rights conferred by the said subclauses either in the interests of the general public or for the protection of the interests of any scheduled tribe. 6 nothing in subclause G of the said clause shall affect the operation of any existing law in so far as it imposes, or prevent the state from making any law imposing, in the interests of the general public, reasonable restrictions on the exercise of the right conferred by the said subclause, and, in particular, 2 nothing in the said subclause shall affect the operation of any existing law in so far as it relates to, or prevent the state from making any law relating to I. The professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business, or E. The carrying on by the state, or by a corporation owned or controlled by the state, of any trade, business, industry or service, whether to the exclusion, complete or partial, of citizens or otherwise. 20. 1. No person shall be convicted of any offense except for violation of a law in force at the time of the commission of the act charged as an offense, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offense. 2. No person shall be prosecuted and punished for the same offense more than once. 3. No person accused of any offense shall be compelled to be a witness against himself. 21. No person shall be deprived of his life or personal liberty except according to procedure established by law. Part 3, Fundamental Rights, Arts. 19, 21. 1 subs. By the Constitution, 44th Amendment, Act, 1978, s. 2, 4, subclauses D, E, and F, W, E, F. The 20th of June 1979. 2 subs. By the Constitution, First Amendment, Act, 1951, s. 3, for certain words. Protection in respect of conviction for offenses. Protection of life and personal liberty. Asterisk 21a. The state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may, by law, determine. 22. 1. No person who is arrested shall be detained in custody without being informed, as soon as may be, of the grounds for such arrest, nor shall he be denied the right to consult, and to be defended by, a legal practitioner of his choice. 2. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. 3. Nothing in clauses 1 and 2 shall apply. A. To any person who for the time being is an enemy alien, or B. To any person who is arrested or detained under any law providing for preventive detention. Asterisk 4. No law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless A. An advisory board consisting of persons who are, or have been, or are qualified to be appointed. Part 3, Fundamental Rights, Arts. 21a22. Ins by the Constitution, 86th Amendment, Act 2002, s. 2, which is not yet in force, date to be notified later on. CL. 4, shall stand substituted by the Constitution, 44th Amendment, Act, 1978, s. 3, which is yet not in force, date to be notified later on, as 4. No law providing for preventive detention shall authorize the detention of a person for a longer period than 2 months unless an advisory board constituted in accordance with the recommendations of the Chief Justice of the appropriate High Court has reported before the expiration of the said period of 2 months that there is in its opinion sufficient cause for such detention. provided that an advisory board shall consist of a chairman and not less than 2 other members, and the chairman shall be a serving judge of the appropriate high court and the other members shall be serving or retired judges of any high court. Provided further that nothing in this clause shall authorize the detention of any person beyond the maximum period prescribed by any law made by Parliament under subclause A of Clause 7. Explanation: in this clause, appropriate high court means in the case of the detention of a person in pursuance of an order of detention made by the Government of India or an officer or authority subordinate to that government, the High Court for the Union Territory of Delhi. In the case of the detention of a person in pursuance of an order of detention made by the government of any state, other than a Union Territory, the High Court for the state, and in the case of the detention of a person in pursuance of an order of detention made by the administrator of a Union Territory or an officer or authority subordinate to such administrator, such High Court as may be specified by or under any law made by Parliament in this behalf. Right to education. Protection against arrest and detention in certain cases. As judges of a high court has reported before the expiration of the said period of 3 months that there is in its opinion sufficient cause for such detention. Provided that nothing in this sub-clause shall authorize the detention of any person beyond the maximum period prescribed by any law made by Parliament under sub-clause B of Clause 7, or B. Such person is detained in accordance with the provisions of any law made by Parliament under subclauses A and B of Clause 7. 5. When any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order. 6. Nothing in Clause 5 shall require the authority making any such order as is referred to in that clause to disclose facts which such authority considers to be against the public interest to disclose. 7. Parliament may by law prescribe A. The circumstances under which, and the class or classes of cases in which, a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board in accordance with the provisions of subclause A of Clause 4. B. The maximum period for which any person may in any class or classes of cases be detained under any law providing for preventive detention, and C. The procedure to be followed by an advisory board in an inquiry under subclause A of Clause 4. Part 3. Fundamental Rights, Art. 22. Subclause A shall stand omitted by the Constitution, 44th Amendment, Act, 1978, S. 3, which is yet not in force, date to be notified later on. Subclause B shall stand relettered as subclause A by S. 3, ibid, which is yet not in force, date to be notified later on. The words, letter and figure in brackets shall stand substituted as Clause 4 by S. 3, ibid, which is yet not in force, date to be notified later on. Right against exploitation. 23. 1. Traffic in human beings and begar and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offense punishable in accordance with law. 2. Nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such service the state shall not make any discrimination on grounds only of religion, race, caste or class or any of them. 24. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. Right to freedom of religion. 25. 1. Subject to public order, morality and health and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice and propagate religion. 2. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law. A. Regulating or restricting any economic, financial, political or other secular activity which may be associated with religious practice. B. Providing for social welfare and reform or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Explanation I. The wearing and carrying of kirpans shall be deemed to be included in the profession of the Sikh religion. Explanation 2. In subclause B of Clause 2, the reference to Hindus shall be construed as including a reference to persons professing the Sikh, Jaina or Buddhist religion, and the reference to Hindu religious institutions shall be construed accordingly. 26. Subject to public order, morality and health, every religious denomination or any section thereof shall have the right a. To establish and maintain institutions for religious and charitable purposes. B. To manage its own affairs in matters of religion. Prohibition of employment of children in factories, etc. Freedom of conscience and free profession, practice and propagation of religion. Prohibition of traffic in human beings and forced labor. Freedom to manage religious affairs. Part 3, Fundamental Rights, Arts. 23, 26. C. To own and acquire movable and immovable property, and D. To administer such property in accordance with law. 27. No person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. 28. 1. No religious instruction shall be provided in any educational institution wholly maintained out of state funds. 2. Nothing in Clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution. 3. No person attending any educational institution recognized by the state or receiving aid out of state funds shall be required to take part in any religious instruction that may be imparted in such institution or to attend any religious worship that may be conducted in such institution or in any premises attached thereto unless such person or, if such person is a minor, his guardian has given his consent thereto. Cultural and educational rights 29. 1. Any section of the citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. 2. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language or any of them. 30. 1. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. 1a. In making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority. Freedom as to payment of taxes for promotion of any particular religion. Freedom as to attendance at religious instruction or religious worship in certain educational institutions. Protection of interests of minorities. Right of minorities to establish and administer educational institutions. 1 ins. By the Constitution, 44th Amendment, Act, 1978, S. 4 W. E. F. The 20th of June 1979. Part 3, Fundamental Rights, Arts. 2630. Referred to in Clause 1, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under that clause. 2. The state shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. 1 ****. 31. Compulsory acquisition of property, representative. By the Constitution, 44th Amendment, Act, 1978, S. 6 W. E. F. The 20th of June 1979. 2. Saving of certain laws. 331a. 4. 1. Notwithstanding anything contained in Article 13, no law providing for a. The acquisition by the state of any estate or of any rights therein or the extinguishment or modification of any such rights, or b. The taking over of the management of any property by the state for a limited period either in the public interest or in order to secure the proper management of the property, or c. The amalgamation of two or more corporations either in the public interest or in order to secure the proper management of any of the corporations, or D. The extinguishment or modification of any rights of managing agents, secretaries and treasurers, managing directors, directors or managers of corporations, or of any voting rights of shareholders thereof, or saving of laws providing for acquisition of estates, etc. 1. The subheading, Right to Property, omitted by the Constitution, 44th Amendment, Act, 1978, S. 5W, E, F. The 20th of June 1979. 2 ins. By the Constitution, 42nd Amendment, Act, 1976, S. 3 W, E, F. The 1st of March 1977. 3 ins. By the Constitution, First Amendment, Act, 1951, S. 4 with retrospective effect. 4 subs. By the Constitution, Fourth Amendment, Act, 1955, S. 3 per CL. 1 with retrospective effect. Part 3, Fundamental Rights, Arts. 30-31A. E. The extinguishment or modification of any rights accruing by virtue of any agreement, lease or license for the purpose of searching for, or winning, any mineral or mineral oil, or the premature termination or cancellation of any such agreement, lease or license, shall be deemed to be void on the ground that it is inconsistent with, or takes away or abridges any of the rights conferred by 1. Article 14 or Article 19. Provided that where such law is a law made by the legislature of a state, the provisions of this article shall not apply thereto unless such law, having been reserved for the consideration of the President, has received his assent. 2. Provided further that where any law makes any provision for the acquisition by the state of any estate and where any land comprised therein is held by a person under his personal cultivation, it shall not be lawful for the state to acquire any portion of such land as is within the ceiling limit applicable to him under any law for the time being in force or any building or structure standing thereon or appertenant thereto, unless the law relating to the acquisition of such land, building or structure, provides for payment of compensation at a rate which shall not be less than the market value thereof. 2. In this article. 3a. The expression, estate, shall, in relation to any local area, have the same meaning as that expression or its local equivalent has in the existing law relating to land tenures in force in that area and shall also include any Jagier, Inamurmawafi or other similar grant and in the states of 4. Tamil Nadu, and Kerala, any Janmam right. 1 subs. By the Constitution, 44th Amendment, Act, 1978, S. 7, 4, Article 14. Article 19 or Article 31 inches W, E, F. The 20th of June 1979. 2 ins. By the Constitution, 17th Amendment, Act, 1964, S. 2. 3 subs. By S. 2, Ibid, for subclause A, with retrospective effect. 4 subs. By the Madras State, Alteration of Name, Act, 1968, 53 of 1968, S. 4, 4, Madras. W, E, F. The 14th of January 1969. Part 3, Fundamental Rights, Art. 31A. E. Any land held under Ryotwari settlement. E. Any land held or let for purposes of agriculture or for purposes ancillary thereto, including waste land, forest land, land for pasture or sites of buildings and other structures occupied by cultivators of land, agricultural laborers and village artisans. B. The expression, rights, in relation to an estate, shall include any rights vesting in a proprietor, subproprietor, underproprietor, tenure holder, 1, rate, under rate, or other intermediary and any rights or privileges in respect of land revenue. 231b. Without prejudice to the generality of the provisions contained in Article 31A, none of the acts and regulations specified in the 9th Schedule nor any of the provisions thereof shall be deemed to be void, or ever to have become void, on the ground that such act, regulation or provision is inconsistent with, or takes away or abridges any of the rights conferred by, any provisions of this part, and notwithstanding any judgment, decree or order of any court or tribunal to the contrary, each of the said acts and regulations shall, subject to the power of any competent legislature to repeal or amend it, continue in force. 331c. Notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing for all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with, or takes away or abridges any of the rights conferred by 5, Article 14 or Article 19, 6 and no law. Validation of certain acts and regulations. 1 ins. By the Constitution, 4th Amendment, Act, 1955, s. 3, with retrospective effect. 2 ins. By the Constitution, 1st Amendment, Act, 1951, s. 5. 3 ins. By the Constitution, 25th Amendment, Act, 1971, s. 3, w, e, f. The 20th of April 1972. 4 subs. By the Constitution, 42nd Amendment, Act, 1976, s. 4. The principles specified in Clause B, or Clause C, of Article 39, W, E, F. The 1st of March 1977. Section 4 has been declared invalid by the Supreme Court in Minerva Mills Limited, and others versus Union of India and others 19802. SCC. 591. 5 subs. By the Constitution, 44th Amendment, Act, 1978, s. 8. Article 14. Article 19 or Article 31 inches W, E, F. The 20th of June 1979. 6 in Kesavananda Bharati versus the State of Kerala, 1973, Sup. SCR. 1. The Supreme Court held the provisions in italics to be invalid. Saving of laws giving effect to certain directive principles. Part 3, Fundamental Rights, Arts. 31A, 31C. Containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. Provided that where such law is made by the legislature of a state, the provisions of this article shall not apply thereto unless such law, having been reserved for the consideration of the President, has received his assent. 131d. Saving of laws in respect of anti-national activities, representative. By the Constitution, 43rd Amendment, Act, 1977, s. 2, w, e, f. The 13th of April 1978. Right to constitutional remedies. 32. 1. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. 2. The Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, whichever may be appropriate, for the enforcement of any of the rights conferred by this part. 3. Without prejudice to the powers conferred on the Supreme Court by Clauses 1 and 2, Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under Clause 2. 4. The right guaranteed by this article shall not be suspended except as otherwise provided for by this Constitution. 232a. Constitutional validity of state laws not to be considered in proceedings under Article 32, representative. By the Constitution, 43rd Amendment, Act, 1977, s. 3, w, e, f. The 13th of April 1978. Remedies for enforcement of rights conferred by this part. 1 ins. By the Constitution, 42nd Amendment, Act, 1976, s. 5 w, e, f. The 1st of March 1977. 2 ins. By S. 6, Ibid. W, E, F. The 2nd of January 1977. Part 3, Fundamental Rights, Arts. 31C, 32A. 133. Parliament may, by law, determine to what extent any of the rights conferred by this part shall, in their application to a. the members of the armed forces, or b. the members of the forces charged with the maintenance of public order, or c. persons employed in any bureau or other organization established by the state for purposes of intelligence or counterintelligence, or d. person employed in, or in connection with, the telecommunication system set up for the purposes of any force, bureau or organization referred to in clauses A to C. Be restricted or abrogated so as to ensure the proper discharge of their duties and the maintenance of discipline among them. 34. Notwithstanding anything in the foregoing provisions of this part, Parliament may by law indemnify any person in the service of the Union or of a state or any other person in respect of any act done by him in connection with the maintenance or restoration of order in any area within the territory of India where martial law was in force, or validate any sentence passed, punishment inflicted, forfeiture ordered, or other act done under martial law in such area. 35. Notwithstanding anything in this Constitution. A. Parliament shall have, and the legislature of a state shall not have power to make laws. I. With respect to any of the matters which under Clause 3 of Article 16, Clause 3 of Article 32, Article 33 and Article 34 may be provided for by law made by Parliament, and E. For prescribing punishment for those acts which are declared to be offences under this part. Power of Parliament to modify the rights conferred by this part in their application to forces, etc. Restriction on rights conferred by this part while martial law is in force in any area. Legislation to give effect to the provisions of this part. 1 subs. By the Constitution, 50th Amendment, Act, 1984, S. 2, for Art. 33. Part 3, Fundamental Rights, Arts. 33, 35. And Parliament shall, as soon as may be after the commencement of this Constitution, make laws for prescribing punishment for the acts referred to in subclause E. B. Any law in force immediately before the commencement of this Constitution in the territory of India with respect to any of the matters referred to in subclause I of Clause A, or providing for punishment for any act referred to in subclause E of that clause shall, subject to the terms thereof and to any adaptations and modifications that may be made therein under Article 372, continue in force until altered or repealed or amended by Parliament. Explanation: in this article, the expression, law in force, has the same meaning as in Article 372. Part 3, Fundamental Rights, Art. 35. Part 4. Directive Principles of State Policy. 36. In this part, unless the context otherwise requires, the state, has the same meaning as in Part 3. 37. The provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. 38. 1. The state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic and political, shall inform all the institutions of the national life. 2. The state shall, in particular, strive to minimize the inequalities in income, and endeavor to eliminate inequalities in status, facilities and opportunities, not only amongst individuals but also amongst groups of people residing in different areas or engaged in different vocations. 39. The state shall, in particular, direct its policy towards securing a. That the citizens, men and women equally, have the right to an adequate means of livelihood. B. That the ownership and control of the material resources of the community are so distributed as best to subserve the common good. C. That the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. D. That there is equal pay for equal work for both men and women. Definition. Application of the principles contained in this part. State to secure a social order for the promotion of welfare of the people. Certain principles of policy to be followed by the state. 1 Art. 38 renumbered as Cl. 1 thereof by the Constitution, 44th Amendment. Act, 1978, S. 9, W, E, F. The 20th of June 1979. 2 Ins. By S. 9, Ibid. W, E, F. The 20th of June 1979. 21. E. That the health and strength of workers, men and women, and the tender age of children are not abused, and that citizens are not forced by economic necessity to enter avocations unsuited to their age or strength. 1. F. That children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. 239A. The state shall secure that the operation of the legal system promotes justice, on a basis of equal opportunity, and shall, in particular, provide free legal aid, by suitable legislation or schemes or in any other way, to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. 40. The state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. 41. The state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education and to public assistance in cases of unemployment, old age, sickness and disablement, and in other cases of undeserved want. 42. The state shall make provision for securing just and humane conditions of work and for maternity relief. 43. The state shall endeavor to secure, by suitable legislation or economic organization or in any other way, to all workers, agricultural, industrial or otherwise, work, a living wage, conditions of work ensuring a decent 1 subs. By the Constitution, 42nd Amendment, Act, 1976, S. 7, for cl. FWEF. The 1st of March 1977. 2 ins. By S. 8, Ibid. WEF. The 1st of March 1977. Equal justice and free legal aid. Organization of village panchayats. Right to work, to education and to public assistance in certain cases. Provision for just and humane conditions of work and maternity relief. Living wage, etc., for workers. Part 4, Directive Principles of State Policy, Arts. 39-43. Standard of life and full enjoyment of leisure and social and cultural opportunities and, in particular, the state shall endeavor to promote cottage industries on an individual or cooperative basis in rural areas. 143A. The state shall take steps, by suitable legislation or in any other way, to secure the participation of workers in the management of undertakings, establishments or other organizations engaged in any industry. 44. The state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. 45. The state shall endeavor to provide, within a period of 10 years from the commencement of this Constitution, for free and compulsory education for all children until they complete the age of 14 years. 46. The state shall promote with special care the educational and economic interests of the weaker sections of the people, and, in particular, of the scheduled castes and the scheduled tribes, and shall protect them from social injustice and all forms of exploitation. 47. The state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as among its primary duties and, in particular, the state shall endeavor to bring about prohibition of the consumption except for medicinal purposes of intoxicating drinks and of drugs which are injurious to health. 48. The state shall endeavor to organize agriculture and animal husbandry on modern and scientific lines and shall, in particular, take steps for preserving and improving the breeds, and prohibiting the slaughter, of cows and calves and other milch and draft cattle. Participation of workers in management of industries. Uniform civil code for the citizens. Provision for free and compulsory education for children. 1 ins. By the Constitution, 42nd Amendment, Act, 1976, S. 9, W.E.F. The 1st of March 1977. Art. 45 shall stand substituted by the Constitution, 86th Amendment, Act, 2002, S. 3, which is yet not in force, date to be notified later on, as 45. Provision for early childhood care and education to children below the age of 6 years. The state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. Promotion of educational and economic interests of scheduled castes, scheduled tribes and other weaker sections. Duty of the state to raise the level of nutrition and the standard of living and to improve public health. Organization of agriculture and animal husbandry. Part 4, Directive Principles of State Policy, Arts. 43-48A. Protection and improvement of environment and safeguarding of forests and wildlife. 148A. The state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. 49. It shall be the obligation of the state to protect every monument or place or object of artistic or historic interest, 2, declared by or under law made by Parliament to be of national importance, from spoliation, disfigurement, destruction, removal, disposal or export, as the case may be. 50. The state shall take steps to separate the judiciary from the executive and the public services of the state. 51. The state shall endeavor to a. Promote international peace and security. B. Maintain just and honorable relations between nations. C. Foster respect for international law and treaty obligations in the dealings of organized peoples with one another, and D. Encourage settlement of international disputes by arbitration. 1 ends. By the Constitution, 42nd Amendment, Act, 1976, S. 10, W, E, F. The 1st of March 1977. 2 subs. By the Constitution, 7th Amendment, Act, 1956, S. 27, 4, declared by Parliament by law. Protection of monuments and places and objects of national importance. Separation of judiciary from executive. Part 4, Directive Principles of State Policy, Arts. 48A, 51. Promotion of international peace and security. 1. Part EVA. Fundamental duties. 51A. It shall be the duty of every citizen of India a. To abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. b. To cherish and follow the noble ideals which inspired our national struggle for freedom. c. To uphold and protect the sovereignty, unity and integrity of India. d. To defend the country and render national service when called upon to do so. e. To promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities, to renounce practices derogatory to the dignity of women. f. To value and preserve the rich heritage of our composite culture. g. To protect and improve the natural environment including forests, lakes, rivers and wildlife, and to have compassion for living creatures. h. To develop the scientific temper, humanism and the spirit of inquiry and reform. I. To safeguard public property and to abjure violence. j. To strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement. K. Who is a parent or guardian to provide opportunities for education to his child or, as the case may be, ward between the age of 6 and 14 years. Fundamental duties. 1 ends. By the Constitution, 42nd Amendment, Act, 1976, S. 11, W, E, F. The 1st of March 1977. Ins. By the Constitution, 86th Amendment, Act, 2002, S. 4, which is yet not in force, date to be notified later on. 25. Part 5. The Union CHAPTERITEXECUTIVE, the President and Vice President. 52. There shall be a President of India. 53. 1. The executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution. 2. Without prejudice to the generality of the foregoing provision, the supreme command of the defense forces of the Union shall be vested in the President and the exercise thereof shall be regulated by law. 3. Nothing in this article shall a. Be deemed to transfer to the President any functions conferred by any existing law on the government of any state or other authority, or b. Prevent Parliament from conferring by law functions on authorities other than the President. 54. The President shall be elected by the members of an electoral college consisting of a. The elected members of both houses of Parliament, and b. The elected members of the legislative assemblies of the states. 1. Explanation. In this article and in Article 55, state includes the National Capital Territory of Delhi and the Union Territory of Pondicherry. The President of India. Executive power of the Union. 1 ends. By the Constitution, 70th Amendment, Act, 1992, S. 2, W, E, F. the 6th of January 1995. Asterisk now Puducherry, Vaidhi the Pondicherry, Alteration of Name, Act 2006, S. 3, W, E, F. The 10th of January 2006. 26. Election of President. 55. 1. As far as practicable, there shall be uniformity in the scale of representation of the different states at the election of the President. 2. For the purpose of securing such uniformity among the states inter se as well as parity between the states as a whole and the Union, the number of votes which each elected member of Parliament and of the Legislative Assembly of each state is entitled to cast at such election shall be determined in the following manner. A. Every elected member of the Legislative Assembly of a state shall have as many votes as there are multiples of 1,000 in the quotient obtained by dividing the population of the state by the total number of the elected members of the Assembly. B. If, after taking the said multiples of 1,000, the remainder is not less than 500, then the vote of each member referred to in sub-clause A shall be further increased by 1. C. Each elected member of either House of Parliament shall have such number of votes as may be obtained by dividing the total number of votes assigned to the members of the legislative assemblies of the states under sub-clauses A and B by the total number of the elected members of both Houses of Parliament, fractions exceeding one half being counted as one and other fractions being disregarded. 3. The election of the President shall be held in accordance with the system of proportional representation by means of the single transferable vote, and the voting at such election shall be by secret ballot. 1. Explanation. In this article, the expression population means the population as ascertained at the last preceding census of which the relevant figures have been published. Provided that the reference in this explanation to the last preceding census of which the relevant figures have. Manner of election of President. 1 subs. By the Constitution, 42nd Amendment, Act, 1976, S. 12 for the explanation, W, E, F. The 1st of March 1977. Part 5, the Union, Art. 55. Been published shall, until the relevant figures for the first census taken after the year 1, 2026, have been published, be construed as a reference to the 1971 census. 56. 1. The President shall hold office for a term of 5 years from the date on which he enters upon his office. Provided that A. The President may, by writing under his hand addressed to the Vice President, resign his office. B. The President may, for violation of the Constitution, be removed from office by impeachment in the manner provided in Article 61. C. The President shall, notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. 2. Any resignation addressed to the Vice President under Clause A of the proviso to Clause 1 shall forthwith be communicated by him to the Speaker of the House of the People. 57. A person who holds, or who has held, office as President shall, subject to the other provisions of this Constitution, be eligible for re-election to that office. 58. 1. No person shall be eligible for election as President unless he A. is a citizen of India, B. has completed the age of 35 years, and C. is qualified for election as a member of the House of the People. 2. A person shall not be eligible for election as President if he holds any office of profit under the Government of India or the Government of any state or under any local or other authority subject to the control of any of the said governments. Term of office of President. Qualifications for election as President. Eligibility for re-election. 1 subs. By the Constitution, 84th Amendment, Act 2001, S. 2, 4, 2000. Part 5, the Union, Arts. 55-58. Explanation. For the purposes of this article, a person shall not be deemed to hold any office of profit by reason only that he is the President or Vice President of the Union or the Governor 1*** of any state or is a minister either for the Union or for any state. 59. 1. The President shall not be a member of either House of Parliament or of a House of the Legislature of any state, and if a member of either House of Parliament or of a House of the Legislature of any state be elected President, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as President. 2. The President shall not hold any other office of profit. 3. The President shall be entitled without payment of rent to the use of his official residences and shall be also entitled to such emoluments, allowances and privileges as may be determined by Parliament by law and, until provision in that behalf is so made, such emoluments, allowances and privileges as are specified in the second schedule. 4. The emoluments and allowances of the President shall not be diminished during his term of office. 60. Every President and every person acting as President or discharging the functions of the President shall, before entering upon his office, make and subscribe in the presence of the Chief Justice of India or, in his absence, the senior-most judge of the Supreme Court available, an oath or affirmation in the following form, that is to say, I, A.B., do swear in the name of God that I will solemnly affirm fully execute the office of President or discharge the functions of the President of India and will to the best of my ability preserve, protect and defend the conditions of President's office. Oath or affirmation by the President. 1. The words, or Raj Pramukh or Aparaj Pramukh, omitted by the Constitution, 7th Amendment, Act, 1956, S. 29 and SCH. Part 5, the Union, Arts. 58-60. Constitution and the law and that I will devote myself to the service and well-being of the people of India. 61. 1. When a President is to be impeached for violation of the Constitution, the charge shall be preferred by either House of Parliament. 2. No such charge shall be preferred unless a. The proposal to prefer such charge is contained in a resolution which has been moved after at least 14 days' notice in writing signed by not less than 1/4 of the total number of members of the House has been given of their intention to move the resolution, and b. Such resolution has been passed by a majority of not less than 2/3 of the total membership of the House. 3. When a charge has been so preferred by either House of Parliament, the other House shall investigate the charge or cause the charge to be investigated and the President shall have the right to appear and to be represented at such investigation. 4. If as a result of the investigation a resolution is passed by a majority of not less than 2/3 of the total membership of the House by which the charge was investigated or caused to be investigated, declaring that the charge preferred against the President has been sustained, such resolution shall have the effect of removing the President from his office as from the date on which the resolution is so passed. 62. 1. An election to fill a vacancy caused by the expiration of the term of office of President shall be completed before the expiration of the term. 2. An election to fill a vacancy in the office of President occurring by reason of his death, resignation or removal, or otherwise shall be held as soon as possible after, and in no case later than 6 months from, the date of occurrence of the vacancy, and the person elected to fill the vacancy shall, subject to the provisions of Article 56. Procedure for impeachment of the President. Time of holding election to fill vacancy in the office of President and the term of office of person elected to fill casual vacancy. Part 5, the Union, Arts. 60-62. Be entitled to hold office for the full term of 5 years from the date on which he enters upon his office. 63. There shall be a Vice President of India. 64. The Vice President shall be ex officio Chairman of the Council of States and shall not hold any other office of profit. Provided that during any period when the Vice President acts as President or discharges the functions of the President under Article 65, he shall not perform the duties of the office of Chairman of the Council of States and shall not be entitled to any salary or allowance payable to the Chairman of the Council of States under Article 97. 65. 1. In the event of the occurrence of any vacancy in the office of the President by reason of his death, resignation or removal, or otherwise, the Vice President shall act as President until the date on which a new President elected in accordance with the provisions of this chapter to fill such vacancy enters upon his office. 2. When the President is unable to discharge his functions owing to absence, illness or any other cause, the Vice President shall discharge his functions until the date on which the President resumes his duties. 3. The Vice President shall, during, and in respect of, the period while he is so acting as, or discharging the functions of President, have all the powers and immunities of the President and be entitled to such emoluments, allowances and privileges as may be determined by Parliament by law and, until provision in that behalf is so made, such emoluments, allowances and privileges as are specified in the second schedule. 66. 1. The Vice President shall be elected by the 1. Members of an electoral college consisting of the members of both Houses of Parliament, in accordance. The Vice President of India. The Vice President to be ex officio Chairman of the Council of States. The Vice President to act as President or to discharge his functions during casual vacancies in the office, or during the absence of President. Election of Vice President. 1 subs. By the Constitution, 11th Amendment, Act, 1961, s. 2, 4, members of both Houses of Parliament assembled at a joint meeting. Part 5, the Union, Arts. 62, 66. With the system of proportional representation by means of the single transferable vote and the voting at such election shall be by secret ballot. 2. The Vice President shall not be a member of either House of Parliament or of a House of the Legislature of any state, and if a member of either House of Parliament or of a House of the Legislature of any state be elected Vice President, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as Vice President. 3. No person shall be eligible for election as Vice President unless he a. is a citizen of India, b. has completed the age of 35 years, and c. is qualified for election as a member of the Council of States. 4. A person shall not be eligible for election as Vice President if he holds any office of profit under the Government of India or the Government of any state or under any local or other authority subject to the control of any of the said governments. Explanation: for the purposes of this article, a person shall not be deemed to hold any office of profit by reason only that he is the President or Vice President of the Union or the Governor 1*** of any state or is a minister either for the Union or for any state. 67. The Vice President shall hold office for a term of 5 years from the date on which he enters upon his office, provided that a Vice President may, by writing under his hand addressed to the President, resign his office. Term of office of Vice President. 1. The words, or Raj Pramukh or Aparaj Pramukh, omitted by the Constitution, 7th Amendment, Act, 1956, s. 29 and sch. Part 5, the Union, Arts. 66, 67. b. A Vice President may be removed from his office by a resolution of the Council of States passed by a majority of all the then members of the Council and agreed to by the House of the People, but no resolution for the purpose of this clause shall be moved unless at least 14 days' notice has been given of the intention to move the resolution. c. A Vice President shall, notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. 68. 1. An election to fill a vacancy caused by the expiration of the term of office of Vice President shall be completed before the expiration of the term. 2. An election to fill a vacancy in the office of Vice President occurring by reason of his death, resignation or removal, or otherwise shall be held as soon as possible after the occurrence of the vacancy, and the person elected to fill the vacancy shall, subject to the provisions of Article 67, be entitled to hold office for the full term of 5 years from the date on which he enters upon his office. 69. Every Vice President shall, before entering upon his office, make and subscribe before the President, or some person appointed in that behalf by him, an oath or affirmation in the following form, that is to say, I, A.B., do swear in the name of God that I will bear true faith and allegiance to the Constitution of India as by law established and that I will faithfully discharge the duty upon which I am about to enter. 70. Parliament may make such provisions as it thinks fit for the discharge of the functions of the President in any contingency not provided for in this chapter. 171. 1. All doubts and disputes arising out of or in connection with the election of a President or Vice President shall be inquired into and decided by the Supreme Court, whose decision shall be final. Time of holding election to fill vacancy in the office of Vice President and the term of office of person elected to fill casual vacancy. Oath or affirmation by the Vice President. Discharge of Presidents. Functions and other contingencies. Matters relating to, or connected with, the election of a President or Vice President. 1 Art. 71 has been successively subs. By the Constitution, 39th Amendment, Act, 1975, S. 2, W, E, F. The 8th of October 1975, and the Constitution, 44th Amendment, Act, 1978, S. 10, to read as above. W, E, F. The 20th of June 1979. Solemnly affirm, Part 5, the Union, Arts. 67, 71. 2. If the election of a person as President or Vice President is declared void by the Supreme Court, acts done by him in the exercise and performance of the powers and duties of the office of President or Vice President, as the case may be, on or before the date of the decision of the Supreme Court shall not be invalidated by reason of that declaration. 3. Subject to the provisions of this Constitution, Parliament may by law regulate any matter relating to or connected with the election of a President or Vice President. 4. The election of a person as President or Vice President shall not be called in question on the ground of the existence of any vacancy for whatever reason among the members of the Electoral College electing him. 72. 1. The President shall have the power to grant pardons, reprieves, respites or remissions of punishment or to suspend, remit or commute the sentence of any person convicted of any offense. A. In all cases where the punishment or sentence is by a court-martial. B. In all cases where the punishment or sentence is for an offense against any law relating to a matter to which the executive power of the Union extends. C. In all cases where the sentence is a sentence of death. 2. Nothing in sub-clause A of Clause 1 shall affect the power conferred by law on any officer of the armed forces of the Union to suspend, remit or commute a sentence passed by a court-martial. 3. Nothing in sub-clause C of Clause 1 shall affect the power to suspend, remit or commute a sentence of death exercisable by the Governor 1*** of a state under any law for the time being in force. Power of President to grant pardons, etc., and to suspend, remit or commute sentences in certain cases. 1. The words, or Raj Pramukh, omitted by the Constitution, 7th Amendment, Act, 1956, S. 29 and SCH. Part 5, the Union, Arts. 71, 72. 73. 1. Subject to the provisions of this Constitution, the executive power of the Union shall extend A. To the matters with respect to which Parliament has power to make laws, and B. To the exercise of such rights, authority and jurisdiction as are exercisable by the Government of India by virtue of any treaty or agreement, provided that the executive power referred to in subclause A shall not, save as expressly provided in this Constitution or in any law made by Parliament, extend in any state 1*** to matters with respect to which the legislature of the state has also power to make laws. 2. Until otherwise provided by Parliament, a state and any officer or authority of a state may, notwithstanding anything in this article, continue to exercise in matters with respect to which Parliament has power to make laws for that state such executive power or functions as the state or officer or authority thereof could exercise immediately before the commencement of this Constitution. Council of Ministers. 74. 2. 1. There shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President who shall, in the exercise of his functions, act in accordance with such advice. 3. Provided that the President may require the Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. 2. The question whether any, and if so what, advice was tendered by ministers to the President shall not be inquired into in any court. Extent of executive power of the Union. Council of Ministers to aid and advise. President. 1. The words and letters specified in Part A or Part B of the first schedule, omitted by the Constitution, 7th Amendment, Act, 1956, S. 29 and SCH. 2 subs. By the Constitution, 42nd Amendment, Act, 1976, S. 13, for CL. 1, W, E, F. The 1st of March 1977. 3 ins. By the Constitution, 44th Amendment, Act, 1978, S. 11, W, E, F. The 20th of June 1979. Part 5, the Union, Arts. 73, 74. 75. 1. The Prime Minister shall be appointed by the President and the other ministers shall be appointed by the President on the advice of the Prime Minister. 1a. The total number of ministers, including the Prime Minister, in the Council of Ministers shall not exceed 15% of the total number of members of the House of the People. 1b. A member of either House of Parliament belonging to any political party who is disqualified for being a member of that House under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as a minister under clause 1 for duration of the period commencing from the date of his disqualification till the date on which the term of his office as such member would expire or where he contests any election to either House of Parliament before the expiry of such period till the date on which he is declared elected, whichever is earlier. 2. The ministers shall hold office during the pleasure of the President. 3. The Council of Ministers shall be collectively responsible to the House of the People. 4. Before a minister enters upon his office, the President shall administer to him the oaths of office and of secrecy according to the forms set out for the purpose in the third schedule. 5. A minister who for any period of 6 consecutive months is not a member of either House of Parliament shall at the expiration of that period cease to be a minister. 6. The salaries and allowances of ministers shall be such as Parliament may from time to time by law determine and, until Parliament so determines, shall be as specified in the second schedule. The Attorney General for India 76. 1. The President shall appoint a person who is qualified to be appointed a judge of the Supreme Court to be Attorney General for India. 2. It shall be the duty of the Attorney General to give advice to the Government of India upon such legal other provisions as to ministers. 1 ins. By the Constitution, 91st Amendment, Act 2003, S. 2. Attorney General for India. Part 5, the Union, Arts. 75, 76. Matters, and to perform such other duties of a legal character, as may from time to time be referred or assigned to him by the President, and to discharge the functions conferred on him by or under this Constitution or any other law for the time being in force. 3. In the performance of his duties the Attorney General shall have right of audience in all courts in the territory of India. 4. The Attorney General shall hold office during the pleasure of the President, and shall receive such remuneration as the President may determine. Conduct of Government Business 77. 1. All executive action of the Government of India shall be expressed to be taken in the name of the President. 2. Orders and other instruments made and executed in the name of the President shall be authenticated in such manner as may be specified in Rules 1 to be made by the President, and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the President. 3. The President shall make rules for the more convenient transaction of the business of the Government of India, and for the allocation among ministers of the said business. 2 ****. 78. It shall be the duty of the Prime Minister, a. to communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation. b. To furnish such information relating to the administration of the affairs of the Union and proposals for legislation as the President may call for, and conduct of business of the Government of India. Duties of Prime Minister as respects the furnishing of information to the President, etc. 1. See Notification No. S.O. 2297, dated 3 November 1958, Gazette of India. Extraordinary, 1958, pt. 2, Sec. 3, E.P. 1315, as amended from time to time. 2 CL. 4. Was-ins. By the Constitution, 42nd Amendment, Act, 1976, S. 14, W, E, F. The 1st of March 1977, and omitted by the Constitution, 44th Amendment, Act, 1978, S. 12 W, E, F. The 20th of June 1979. Part 5, the Union, Arts. 76, 78. c. If the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Chapter 2, Parliament. General 79. There shall be a Parliament for the Union which shall consist of the President and two Houses to be known respectively as the Council of States and the House of the People. 80. 1. 2 ****. The Council of States shall consist of a. 12 members to be nominated by the President in accordance with the provisions of Clause 3, and b. not more than 238 representatives of the States 3, and of the Union Territories. 2. The allocation of seats in the Council of States to be filled by representatives of the States 3, and of the Union Territories, shall be in accordance with the provisions in that behalf contained in the fourth schedule. 3. The members to be nominated by the President under sub-clause A of Clause 1 shall consist of persons having special knowledge or practical experience in respect of such matters as the following, namely, literature, science, art and social service. 4. The representatives of each state 4*** in the Council of States shall be elected by the elected members of the Legislative Assembly of the state in accordance with the system of proportional representation by means of the single transferable vote. 5. The representatives of the 5 Union Territories in the Council of States shall be chosen in such manner as Parliament may by law prescribe. Constitution of Parliament. Composition of the Council of States. 1 subs. By the Constitution, 35th Amendment, Act, 1974, s. 3, 4, the Council of States W.E.F. the 3rd of January 1975. 2. The words, subject to the provisions of paragraph 4 of the 10th schedule, omitted by the Constitution, 36th Amendment, Act, 1975, s. 5 W.E.F. the 26th of April 1975. 3. Added by the Constitution, 7th Amendment, Act, 1956, s. 3. 4. The words and letters specified in Part A or Part B of the first schedule, omitted by s. 3. Ibid. 5 subs. By s. 3. Ibid. 4. States specified in Part C of the first schedule. Part 5. The Union, Arts. 78, 80. 1. 81. 1, 2, subject to the provisions of Article 331 3****, the House of the People shall consist of a. not more than 530 members chosen by direct election from territorial constituencies in the states, and b. not more than 520 members to represent the Union Territories, chosen in such manner as Parliament may by law provide. 2. For the purposes of sub-clause A of Clause 1. A. There shall be allotted to each state a number of seats in the House of the People in such manner that the ratio between that number and the population of the state is, so far as practicable, the same for all states, and b. Each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it is, so far as practicable, the same throughout the state. 6. Provided that the provisions of sub-clause A of this clause shall not be applicable for the purpose of allotment of seats in the House of the People to any state so long as the population of that state does not exceed 6 millions. 3. In this article, the expression population means the population as ascertained at the last preceding census of which the relevant figures have been published. 7. Provided that the reference in this clause to the last preceding census of which the relevant figures have been published shall, until the relevant figures for the first census taken after the year 2026, have been published. 9. Be construed. Composition of the House of the People. 1 subs. By the Constitution, 7th Amendment, Act, 1956, s. 4, 4 arts. 81 and 82. 2 subs. By the Constitution, 35th Amendment, Act, 1974 s. 4, 4, subject to the provisions of Article 331 W.E.F. the 3rd of January 1975. 3. The words and figure, and paragraph 4 of the 10th schedule, omitted by the Constitution, 36th Amendment, Act, 1975, s. 5 W.E.F. the 26th of April 1975. 4 subs. By the Goa, Damon and DIU Reorganization Act, 1987, 18 of 1987, s. 63, 4. 525 members W, E, F. The 30th of May 1987. 5 subs. By the Constitution, 31st Amendment, Act, 1973, s. 2, 4, 25. Members. 6 ins. By s. 2, Ibid. 7 ins. By the Constitution, 42nd Amendment, Act, 1976, s. 15, W, E, F. The 1st of March 1977. 8 subs. By the Constitution, 84th Amendment, Act, 2001, s. 3, 4, 2000. 9 subs. By s. 3, Ibid, for certain words. Part 5, the Union, Art. 81. I for the purposes of sub-clause A of clause 2 and the proviso to that clause, as a reference to the 1971 census, and E for the purposes of sub-clause B of clause 2 as a reference to the 2001 census. 82. Upon the completion of each census, the allocation of seats in the House of the People to the states and the division of each state into territorial constituencies shall be readjusted by such authority and in such manner as Parliament may by law determine, provided that such readjustment shall not affect representation in the House of the People until the dissolution of the then existing House. 2. Provided further that such readjustment shall take effect from such date as the President may, by order, specify, and until such readjustment takes effect, any election to the House may be held on the basis of the territorial constituencies existing before such readjustment. Provided also that until the relevant figures for the first census taken after the year 2026, have been published, it shall not be necessary to readjust. I. The allocation of seats in the House of People to the states is readjusted on the basis of the 1971 census, and E. The division of each state into territorial constituencies as may be readjusted on the basis of the 2001 census. Under this article. 83. 1. The Council of States shall not be subject to dissolution, but as nearly as possible 1/3 of the members thereof shall retire as soon as may be on the expiration of every second year in accordance with the provisions made in that behalf by Parliament by law. Readjustment after each census. Duration of Houses of Parliament. 1 subs. By the Constitution, 87th Amendment, Act, 2003, s. 2, 4, 1991. 2 ins. By the Constitution, 42nd Amendment, Act, 1976, s. 16, W, E, F. The 1st of March 1977. 3 subs. By the Constitution, 84th Amendment, Act, 2001, s. 4, 4, 2000. 4 subs. By s. 4, Ibid, for certain words. 5 subs. By the Constitution, 87th Amendment, Act, 2003, s. 3, 4, 1991. Part 5, the Union, Arts. 81, 83. 1 subs. By the Constitution, 44th Amendment, Act, 1978, s. 13, 4, 6 years W, E, F. The 20th of June 1979. The words, 6 years, were subs. For the original words, 5 years, by the Constitution, 42nd Amendment, Act, 1976, s. 17, W, E, F. The 1st of March 1977. 2 subs. By the Constitution, 16th Amendment, Act, 1963, s. 3, for CL. A. 3 subs. By the Constitution, First Amendment, Act, 1951, s. 6, for Art. 85. 2. The House of the People, unless sooner dissolved, shall continue for 5 years from the date appointed for its first meeting and no longer, and the expiration of the said period of 5 years, shall operate as a dissolution of the House. Provided that the said period may, while a proclamation of emergency is in operation, be extended by Parliament by law for a period not exceeding 1 year at a time and not extending in any case beyond a period of 6 months after the proclamation has ceased to operate. 84. A person shall not be qualified to be chosen to fill a seat in Parliament unless he 2. Is a citizen of India, and makes and subscribes before some person authorized in that behalf by the Election Commission an oath or affirmation according to the form set out for the purpose in the third schedule. B. Is, in the case of a seat in the Council of States, not less than 30 years of age, and, in the case of a seat in the House of the People, not less than 25 years of age, and C. Possesses such other qualifications as may be prescribed in that behalf by or under any law made by Parliament. 385. 1. The President shall from time to time summon each House of Parliament to meet at such time and place as he thinks fit, but 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. 2. The President may from time to time, A. Prorogue the Houses or either House, B. Dissolve the House of the People. 86. 1. The President may address either House of Parliament or both Houses assembled together, and for that purpose require the attendance of members. Qualification for membership of Parliament. Sessions of Parliament. Prorogation and dissolution. Right of President to address and send messages to Houses. Part 5. The Union, Arts. 83, 86. 2. The President may send messages to either House of Parliament, whether with respect to a bill then pending in Parliament or otherwise, and a House to which any message is so sent shall with all convenient dispatch consider any matter required by the message to be taken into consideration. 87. 1. At the commencement of 1. The first session after each general election to the House of the People and at the commencement of the first session of each year, the President shall address both Houses of Parliament assembled together and inform Parliament of the causes of its summons. 2. Provision shall be made by the rules regulating the procedure of either House for the allotment of time for discussion of the matters referred to in such address to ****. 88. Every minister and the Attorney General of India shall have the right to speak in, and otherwise to take part in the proceedings of either House, any joint sitting of the Houses, and any committee of Parliament of which he may be named a member, but shall not by virtue of this article be entitled to vote. Officers of Parliament. 89. 1. The Vice President of India shall be ex officio Chairman of the Council of States. 2. The Council of States shall, as soon as may be, choose a member of the Council to be Deputy Chairman thereof, and, so often as the office of Deputy Chairman becomes vacant, the Council shall choose another member to be Deputy Chairman thereof. 90. A member holding office as Deputy Chairman of the Council of States, A. Shall vacate his office if he ceases to be a member of the Council. B. May at any time, by writing under his hand address to the Chairman, resign his office, and C. May be removed from his office by a resolution of the Council passed by a majority of all the then members of the Council. 1 subs. By the Constitution, First Amendment, Act, 1951, s. 7, for every session. 2. The words, and for the precedence of such discussion over other business of the House, omitted by s. 7, ibid. Special address by the President. Rights of Ministers and Attorney General as respects Houses. The Chairman and Deputy Chairman of the Council of States. Vacation and resignation of, and removal from, the office of Deputy Chairman. Part 5. The Union, Arts. 86, 90. Provided that no resolution for the purpose of Clause C shall be moved unless at least 14 days' notice has been given of the intention to move the resolution. 91. 1. While the office of Chairman is vacant, or during any period when the Vice President is acting as, or discharging the functions of President, the duties of the office shall be performed by the Deputy Chairman, or, if the office of Deputy Chairman is also vacant, by such member of the Council of States as the President may appoint for the purpose. 2. During the absence of the Chairman from any sitting of the Council of States, the Deputy Chairman, or, if he is also absent, such person as may be determined by the rules of procedure of the Council, or, if no such person is present, such other person as may be determined by the Council, shall act as Chairman. 92. 1. At any sitting of the Council of States, while any resolution for the removal of the Vice President from his office is under consideration, the Chairman, or while any resolution for the removal of the Deputy Chairman from his office is under consideration, the Deputy Chairman shall not, though he is present, preside, and the provisions of Clause 2 of Article 91 shall apply in relation to every such sitting as they apply in relation to a sitting from which the Chairman, or, as the case may be, the Deputy Chairman, is absent. 2. The Chairman shall have the right to speak in, and otherwise to take part in the proceedings of, the Council of States while any resolution for the removal of the Vice President from his office is under consideration in the Council, but, notwithstanding anything in Article 100, shall not be entitled to vote at all on such resolution or on any other matter during such proceedings. 93. The House of the People shall, as soon as may be, choose 2 members of the House to be respectively Speaker and Deputy Speaker thereof, and, so often as the office of Speaker or Deputy Speaker becomes vacant, the House shall choose another member to be Speaker or Deputy Speaker, as the case may be. Power of the Deputy Chairman or other person to perform the duties of the office of, or to act as, Chairman. The Chairman or the Deputy Chairman not to preside while a resolution for his removal from office is under consideration. The Speaker and Deputy Speaker of the House of the People. Part 5. The Union, Arts. 90, 93. 94. A member holding office as Speaker or Deputy Speaker of the House of the People. A. Shall vacate his office if he ceases to be a member of the House of the People. B. May at any time, by writing under his hand addressed, if such member is the Speaker, to the Deputy Speaker, and if such member is the Deputy Speaker, to the Speaker, resign his office, and C. May be removed from his office by a resolution of the House of the People passed by a majority of all the then members of the House. Provided that no resolution for the purpose of Clause C shall be moved unless at least 14 days' notice has been given of the intention to move the resolution. Provided further that, whenever the House of the People is dissolved, the Speaker shall not vacate his office until immediately before the first meeting of the House of the People after the dissolution. 95. 1. While the office of Speaker is vacant, the duties of the office shall be performed by the Deputy Speaker or, if the office of Deputy Speaker is also vacant, by such member of the House of the People as the President may appoint for the purpose. 2. During the absence of the Speaker from any sitting of the House of the People, the Deputy Speaker or, if he is also absent, such person as may be determined by the rules of procedure of the House, or, if no such person is present, such other person as may be determined by the House, shall act as Speaker. 96. 1. At any sitting of the House of the People, while any resolution for the removal of the Speaker from his office is under consideration, the Speaker, or while any resolution for the removal of the Deputy Speaker from his office is under consideration, the Deputy Speaker shall not, though he is present, preside, and the provisions of Clause 2 of Article 95 shall apply in relation to every vacation and resignation of, and removal from, the offices of Speaker and Deputy Speaker. Power of the Deputy Speaker or other person to perform the duties of the office of, or to act as, Speaker. The Speaker or the Deputy Speaker not to preside while a resolution for his removal from office is under consideration. Part 5. The Union, Arts. 94, 96. Such sitting as they apply in relation to a sitting from which the Speaker, or, as the case may be, the Deputy Speaker, is absent. 2. The Speaker shall have the right to speak in, and otherwise to take part in the proceedings of, the House of the People while any resolution for his removal from office is under consideration in the House, and shall, notwithstanding anything in Article 100, be entitled to vote only in the first instance on such resolution or on any other matter during such proceedings, but not in the case of an equality of votes. 97. There shall be paid to the Chairman and the Deputy Chairman of the Council of States, and to the Speaker and the Deputy Speaker of the House of the People, such salaries and allowances as may be respectively fixed by Parliament by law, and, until provision in that behalf is so made, such salaries and allowances as are specified in the second schedule. 98. 1. Each House of Parliament shall have a separate secretarial staff. Provided that nothing in this clause shall be construed as preventing the creation of posts common to both Houses of Parliament. 2. Parliament may by law regulate the recruitment and the conditions of service of persons appointed to the secretarial staff of either House of Parliament. 3. Until provision is made by Parliament under Clause 2, the President may, after consultation with the Speaker of the House of the People or the Chairman of the Council of States, as the case may be, make rules regulating the recruitment and the conditions of service of persons appointed to the secretarial staff of the House of the People or the Council of States, and any rules so made shall have effect subject to the provisions of any law made under the said clause. Salaries and allowances of the Chairman and Deputy Chairman and the Speaker and Deputy Speaker. Secretariat of Parliament. Part 5, The Union, Arts. 96, 98. Conduct of Business. 99. Every member of either House of Parliament shall, before taking his seat, make and subscribe before the President, or some person appointed in that behalf by him, an oath or affirmation according to the form set out for the purpose in the third schedule. 100. 1. Save as otherwise provided in this Constitution, all questions at any sitting of either House or joint sitting of the Houses shall be determined by a majority of votes of the members present and voting, other than the Speaker or person acting as Chairman or Speaker. The Chairman or Speaker, or person acting as such, shall not vote in the first instance, but shall have and exercise a casting vote in the case of an equality of votes. 2. Either House of Parliament shall have power to act notwithstanding any vacancy in the membership thereof, and any proceedings in Parliament shall be valid notwithstanding that it is discovered subsequently that some person who was not entitled so to do sat or voted or otherwise took part in the proceedings. 3. Until Parliament by law otherwise provides, the quorum to constitute a meeting of either House of Parliament shall be 1/10 of the total number of members of the House. 4. If at any time during a meeting of a House there is no quorum, it shall be the duty of the Chairman or Speaker, or person acting as such, either to adjourn the House or to suspend the meeting until there is a quorum. Disqualifications of members. 101. 1. No person shall be a member of both Houses of Parliament, and provision shall be made by Parliament by law for the vacation by a person who is chosen a member of both Houses of his seat in one House or the other. Oath or affirmation by members. Voting in Houses, power of Houses to act. Notwithstanding vacancies and quorum. Vacation of seats. Part 5, The Union, Arts. 99, 101. 2. No person shall be a member both of Parliament and of a House of the Legislature of a State 1*****, and if a person is chosen a member both of Parliament and of a House of the Legislature of 2, a State, then, at the expiration of such period as may be specified in Rules 3 made by the President, that person's seat in Parliament shall become vacant, unless he has previously resigned his seat in the Legislature of the State. 3. If a member of either House of Parliament A. becomes subject to any of the disqualifications mentioned in 4 Clause 1, or Clause 2, of Article 102, or 5b, resigns his seat by writing under his hand address to the Chairman or the Speaker, as the case may be, and his resignation is accepted by the Chairman or the Speaker, as the case may be, his seat shall thereupon become vacant. 6. Provided that in the case of any resignation referred to in subclause B, if from information received or otherwise and after making such inquiry as he thinks fit, the Chairman or the Speaker, as the case may be, is satisfied that such resignation is not voluntary or genuine, he shall not accept such resignation. 4. If for a period of 60 days a member of either House of Parliament is without permission of the House absent from all meetings thereof, the House may declare his seat vacant. Provided that in computing the said period of 60 days no account shall be taken of any period during 1. The words and letters specified in Part A or Part B of the first schedule, omitted by the Constitution, 7th Amendment, Act, 1956, S. 29 and SCH. 2 subs. By S. 29 and SCH, ibid, such a state. 3. See the Prohibition of Simultaneous Membership Rules, 1950, published with the Ministry of Law Notification No. F. 46/50th C, dated the 26th of January 1950, Gazette of India, Extraordinary, p. 678. 4 subs. By the Constitution, 52nd Amendment, Act, 1985, S. 2, 4 Clause 1, of Article 102, W, E, F. the 3rd of January 1985. 5 subs. By the Constitution, 33rd Amendment, Act, 1974, s. 2, for subclause b. 6 ins. By s. 2, ibid. Part 5, the Union, Art. 101, which the House is prorogued or is adjourned for more than 4 consecutive days. 102. 1. A person shall be disqualified for being chosen as, and for being, a member of either House of Parliament. A. If he holds any office of profit under the Government of India or the Government of any state, other than an office declared by Parliament by law not to disqualify its holder. B. If he is of unsound mind and stands so declared by a competent court. C. If he is an undischarged insolvent. D. If he is not a citizen of India, or has voluntarily acquired the citizenship of a foreign state, or is under any acknowledgement of allegiance or adherence to a foreign state. E. If he is so disqualified by or under any law made by Parliament. 1. Explanation. For the purposes of this clause, a person shall not be deemed to hold an office of profit under the Government of India or the Government of any state by reason only that he is a minister either for the Union or for such state. 2. A person shall be disqualified for being a member of either House of Parliament if he is so disqualified under the 10th Schedule. 3. 103. 1. If any question arises as to whether a member of either House of Parliament has become subject to any of the disqualifications mentioned in Clause 1 of Article 102, the question shall be referred for the decision of the President and his decision shall be final. Disqualifications for membership. Decision on questions as to disqualifications of members. 1 subs. By the Constitution, 52nd Amendment, Act, 1985, s. 342, for the purposes of this article, W. E. F. the 3rd of January 1985, 2 ins. By s. 3, ibid. W. E. F. the 3rd of January 1985. 3 art. 103 has been successively subs. By the Constitution, 42nd Amendment, Act, 1976, s. 20, W. E. F. the 1st of March 1977, and the Constitution, 44th Amendment, Act, 1978, s. 14 to read as above. W. E. F. the 20th of June 1979. Part 5, the Union, Arts. 101, 103. 2. Before giving any decision on any such question, the President shall obtain the opinion of the Election Commission and shall act according to such opinion. 104. If a person sits or votes as a member of either House of Parliament before he has complied with the requirements of Article 99, or when he knows that he is not qualified or that he is disqualified for membership thereof, or that he is prohibited from so doing by the provisions of any law made by Parliament, he shall be liable in respect of each day on which he so sits or votes to a penalty of 500 rupees to be recovered as a debt due to the Union. Powers, privileges and immunities of Parliament and its members. 105. 1. Subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. 2. No member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in Parliament or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of either House of Parliament of any report, paper, votes or proceedings. 3. In other respects, the powers, privileges and immunities of each House of Parliament, and of the members and the committees of each House, shall be such as may from time to time be defined by Parliament by law, and, until so defined, 1. Shall be those of that House and of its members and committees immediately before the coming into force of Section 15 of the Constitution, 44th Amendment, Act, 1978. 4. The provisions of clauses 1, 2, and 3 shall apply in relation to persons who by virtue of this Constitution have the right to speak in, and otherwise to. Penalty for sitting and voting before making oath or affirmation under Article 99 or when not qualified or when disqualified. Powers, privileges, etc., of the Houses of Parliament and of the members and committees thereof. 1 subs. By the Constitution, 44th Amendment, Act, 1978, s. 15, for certain words W. E. F. the 20th of June 1979. Part 5, the Union, Arts. 103, 105. Take part in the proceedings of a House of Parliament or any committee thereof as they apply in relation to members of Parliament. 106. Members of either House of Parliament shall be entitled to receive such salaries and allowances as may from time to time be determined by Parliament by law and, until provision in that respect is so made, allowances at such rates and upon such conditions as were immediately before the commencement of this Constitution applicable in the case of members of the Constituent Assembly of the Dominion of India. Legislative Procedure. 107. 1. Subject to the provisions of Articles 109 and 117 with respect to money bills and other financial bills, a bill may originate in either House of Parliament. 2. Subject to the provisions of Articles 108 and 109, a bill shall not be deemed to have been passed by the Houses of Parliament unless it has been agreed to by both Houses, either without amendment or with such amendments only as are agreed to by both Houses. 3. A bill pending in Parliament shall not lapse by reason of the prorogation of the Houses. 4. A bill pending in the Council of States which has not been passed by the House of the People shall not lapse on a dissolution of the House of the People. 5. A bill which is pending in the House of the People, or which having been passed by the House of the People is pending in the Council of States, shall, subject to the provisions of Article 108, lapse on a dissolution of the House of the People. 108. 1. If after a bill has been passed by one House and transmitted to the other House, a. The bill is rejected by the other House, or b. The Houses have finally disagreed as to the amendments to be made in the bill, or salaries and allowances of members. Provisions as to introduction and passing of bills. Joint sitting of both Houses in certain cases. Part 5, the Union, Arts. 105, 108. C. More than 6 months elapse from the date of the reception of the bill by the other House without the bill being passed by it. The President may, unless the bill has elapsed by reason of a dissolution of the House of the People, notify to the Houses by message if they are sitting or by public notification if they are not sitting, his intention to summon them to meet in a joint sitting for the purpose of deliberating and voting on the bill. Provided that nothing in this clause shall apply to a money bill. 2. In reckoning any such period of 6 months as is referred to in Clause 1, no account shall be taken of any period during which the House referred to in subclause C of that clause is prorogued or adjourned for more than 4 consecutive days. 3. Where the President has under Clause 1 notified his intention of summoning the Houses to meet in a joint sitting, neither House shall proceed further with the bill, but the President may at any time after the date of his notification summon the Houses to meet in a joint sitting for the purpose specified in the notification and, if he does so, the Houses shall meet accordingly. 4. If at the joint sitting of the two Houses the bill, with such amendments, if any, as are agreed to in joint sitting, is passed by a majority of the total number of members of both Houses present and voting, it shall be deemed for the purposes of this Constitution to have been passed by both Houses. Provided that at a joint sitting, a. If the bill, having been passed by one House, has not been passed by the other House with amendments and returned to the House in which it originated, no amendment shall be proposed to the bill other than such amendments, if any, as are made necessary by the delay in the passage of the bill. Part 5, the Union, Art. 108. B. If the bill has been so passed and returned, only such amendments as aforesaid shall be proposed to the bill and such other amendments as are relevant to the matters with respect to which the Houses have not agreed. And the decision of the person presiding as to the amendments which are admissible under this clause shall be final. 5. A joint sitting may be held under this article and a bill passed thereat, notwithstanding that a dissolution of the House of the People has intervened since the President notified his intention to summon the Houses to meet therein. 109. 1. A money bill shall not be introduced in the Council of States. 2. After a money bill has been passed by the House of the People it shall be transmitted to the Council of States for its recommendations and the Council of States shall within a period of 14 days from the date of its receipt of the bill return the bill to the House of the People with its recommendations and the House of the People may thereupon either accept or reject all or any of the recommendations of the Council of States. 3. If the House of the People accepts any of the recommendations of the Council of States, the money bill shall be deemed to have been passed by both houses with the amendments recommended by the Council of States and accepted by the House of the People. 4. If the House of the People does not accept any of the recommendations of the Council of States, the money bill shall be deemed to have been passed by both houses in the form in which it was passed by the House of the People without any of the amendments recommended by the Council of States. 5. If a money bill passed by the House of the People and transmitted to the Council of States for its recommendations is not returned to the House of the Part 5, the Union, Arts. 108-109. Special procedure in respect of money bills. People within the said period of 14 days, it shall be deemed to have been passed by both houses at the expiration of the said period in the form in which it was passed by the House of the People. 110. 1. For the purposes of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters, namely: a. The imposition, abolition, remission, alteration or regulation of any tax. b. The regulation of the borrowing of money or the giving of any guarantee by the Government of India, or the amendment of the law with respect to any financial obligations undertaken or to be undertaken by the Government of India. c. The custody of the Consolidated Fund or the Contingency Fund of India, the payment of monies into or the withdrawal of monies from any such fund. d. The appropriation of monies out of the Consolidated Fund of India. e. The declaring of any expenditure to be expenditure charged on the Consolidated Fund of India or the increasing of the amount of any such expenditure. f. The receipt of money on account of the Consolidated Fund of India or the public account of India or the custody or issue of such money or the audit of the accounts of the Union or of a state, or g. Any matter incidental to any of the matters specified in subclauses A2, F. 2. A bill shall not be deemed to be a money bill by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. Definition of money bills. Part 5, the Union, Arts. 109-110. 3. If any question arises whether a bill is a money bill or not, the decision of the Speaker of the House of the People thereon shall be final. 4. There shall be endorsed on every money bill when it is transmitted to the Council of States under Article 109, and when it is presented to the President for assent under Article 111, the certificate of the Speaker of the House of the People signed by him that it is a money bill. 111. When a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill, or that he withholds assent therefrom. Provided that the President may, as soon as possible after the presentation to him of a bill for assent, return the bill if it is not a money bill to the Houses with a message requesting that they will reconsider the bill or any specified provisions thereof and, in particular, will consider the desirability of introducing any such amendments as he may recommend in his message, and when a bill is so returned, the Houses shall reconsider the bill accordingly, and if the bill is passed again by the Houses with or without amendment and presented to the President for assent, the President shall not withhold assent therefrom. Procedure in financial matters. 112. 1. The President shall in respect of every financial year cause to be laid before both the Houses of Parliament a statement of the estimated receipts and expenditure of the Government of India for that year, in this part referred to as the annual financial statement. 2. The estimates of expenditure embodied in the annual financial statement shall show separately: a. The sums required to meet expenditure described by this Constitution as expenditure charged upon the Consolidated Fund of India, and assent to bills. Annual Financial Statement. Part 5, the Union, Arts. 110-112. b. The sums required to meet other expenditure proposed to be made from the Consolidated Fund of India, and shall distinguish expenditure on revenue account from other expenditure. 3. The following expenditure shall be expenditure charged on the Consolidated Fund of India: a. The emoluments and allowances of the President and other expenditure relating to his office. b. The salaries and allowances of the Chairman and the Deputy Chairman of the Council of States and the Speaker and the Deputy Speaker of the House of the People. c. Debt charges for which the Government of India is liable, including interest, sinking fund charges and redemption charges, and other expenditure relating to the raising of loans and the service and redemption of debt. d. I. The salaries, allowances and pensions payable to or in respect of judges of the Supreme Court. e. The pensions payable to or in respect of judges of the Federal Court. e. The pensions payable to or in respect of judges of any high court which exercises jurisdiction in relation to any area included in the territory of India or which at any time before the commencement of this Constitution exercised jurisdiction in relation to any area included in 1. A governor's province of the Dominion of India. e. The salary, allowances and pension payable to or in respect of the Comptroller and Auditor General of India. 1 subs. By the Constitution, 7th Amendment, Act, 1956, S. 29 and SCH. 4, a province corresponding to a state specified in Part A of the First Schedule. Part 5, the Union, Art. 112. F. Any sums required to satisfy any judgment, decree or award of any court or arbitral tribunal. g. Any other expenditure declared by this Constitution or by Parliament by law to be so charged. 113. 1. So much of the estimates as relates to expenditure charged upon the Consolidated Fund of India shall not be submitted to the vote of Parliament, but nothing in this clause shall be construed as preventing the discussion in either House of Parliament of any of those estimates. 2. So much of the said estimates as relates to other expenditure shall be submitted in the form of demands for grants to the House of the People, and the House of the People shall have power to assent, or to refuse to assent, to any demand, or to assent to any demand subject to a reduction of the amount specified therein. 3. No demand for a grant shall be made except on the recommendation of the President. 114. 1. As soon as may be after the grants under Article 113 have been made by the House of the People, there shall be introduced a bill to provide for the appropriation out of the Consolidated Fund of India of all monies required to meet a. The grants so made by the House of the People, and b. The expenditure charged on the Consolidated Fund of India but not exceeding in any case the amount shown in the statement previously laid before Parliament. 2. No amendment shall be proposed to any such bill in either House of Parliament which will have the effect of varying the amount or altering the destination of any grant so made or of varying the amount of any expenditure charged on the Consolidated Fund of India, and the decision of the person presiding as to whether an amendment is inadmissible under this clause shall be final. Procedure in Parliament with respect to estimates. Appropriation bills. Part 5, the Union, Arts. 112, 114. 3. Subject to the provisions of Articles 115 and 116, no money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law passed in accordance with the provisions of this article. 115. 1. The President shall a. If the amount authorized by any law made in accordance with the provisions of Article 114 to be expended for a particular service for the current financial year is found to be insufficient for the purposes of that year, or when a need has arisen during the current financial year for supplementary or additional expenditure upon some new service not contemplated in the annual financial statement for that year, or b. If any money has been spent on any service during a financial year in excess of the amount granted for that service and for that year. Cause to be laid before both the Houses of Parliament another statement showing the estimated amount of that expenditure, or cause to be presented to the House of the People a demand for such excess, as the case may be. 2. The provisions of Articles 112, 113 and 114 shall have effect in relation to any such statement and expenditure or demand, and also to any law to be made authorizing the appropriation of monies out of the Consolidated Fund of India to meet such expenditure or the grant in respect of such demand as they have effect in relation to the annual financial statement and the expenditure mentioned therein, or to a demand for a grant and the law to be made for the authorization of appropriation of monies out of the Consolidated Fund of India to meet such expenditure or grant. 116. 1. Notwithstanding anything in the foregoing provisions of this chapter, the House of the People shall have power A. To make any grant in advance in respect of the estimated expenditure for a part of any financial, supplementary, additional or excess grants. Votes on account, votes of credit and exceptional grants. Part 5, the Union, Arts. 114, 116. Year pending the completion of the procedure prescribed in Article 113 for the voting of such grant and the passing of the law in accordance with the provisions of Article 114 in relation to that expenditure. B. To make a grant for meeting an unexpected demand upon the resources of India when on account of the magnitude or the indefinite character of the service the demand cannot be stated with the details ordinarily given in an annual financial statement. C. To make an exceptional grant which forms no part of the current service of any financial year, and Parliament shall have power to authorize by law the withdrawal of monies from the Consolidated Fund of India for the purposes for which the said grants are made. 2. The provisions of Articles 113 and 114 shall have effect in relation to the making of any grant under Clause 1, and to any law to be made under that clause as they have effect in relation to the making of a grant with regard to any expenditure mentioned in the annual financial statement and the law to be made for the authorization of appropriation of monies out of the Consolidated Fund of India to meet such expenditure. 117. 1. A bill or amendment making provision for any of the matters specified in subclauses A2, F, of Clause 1, of Article 110 shall not be introduced or moved except on the recommendation of the President, and a bill making such provision shall not be introduced in the Council of States, provided that no recommendation shall be required under this clause for the moving of an amendment making provision for the reduction or abolition of any tax. 2. A bill or amendment shall not be deemed to make provision for any of the matters aforesaid by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission. Special provisions as to financial bills. Part 5, the Union, Arts. 116-117. Alteration or regulation of any tax by any local authority or body for local purposes. 3. A bill which, if enacted and brought into operation, would involve expenditure from the Consolidated Fund of India shall not be passed by either House of Parliament unless the President has recommended to that House the consideration of the bill. Procedure generally. 118. 1. Each House of Parliament may make rules for regulating, subject to the provisions of this Constitution, its procedure and the conduct of its business. 2. Until rules are made under Clause 1, the rules of procedure and standing orders in force immediately before the commencement of this Constitution with respect to the legislature of the Dominion of India shall have effect in relation to Parliament subject to such modifications and adaptations as may be made therein by the Chairman of the Council of States or the Speaker of the House of the People, as the case may be. 3. The President, after consultation with the Chairman of the Council of States and the Speaker of the House of the People, may make rules as to the procedure with respect to joint sittings of, and communications between, the two Houses. 4. At a joint sitting of the two Houses the Speaker of the House of the People, or in his absence such person as may be determined by rules of procedure made under Clause 3, shall preside. 119. Parliament may, for the purpose of the timely completion of financial business, regulate by law the procedure of, and the conduct of business in, each House of Parliament in relation to any financial matter or to any bill for the appropriation of monies out of the Consolidated Fund of India, and, if and so far as any provision of any law so made is inconsistent with any rule made by a House of Parliament under Clause 1, of Article 118 or with any rule or standing order having rules of procedure. Regulation by law of procedure in Parliament in relation to financial business. Part 5, the Union, Arts. 117, 119. Effect in relation to Parliament under Clause 2, of that article, such provision shall prevail. 120. 1. Notwithstanding anything in Part 17, but subject to the provisions of Article 348, business in Parliament shall be transacted in Hindi or in English. provided that the chairman of the Council of States or Speaker of the House of the People, or person acting as such, as the case may be, may permit any member who cannot adequately express himself in Hindi or in English to address the House in his mother tongue. 2. Unless Parliament by law otherwise provides, this article shall, after the expiration of a period of 15 years from the commencement of this Constitution, have effect as if the words, or in English, were omitted therefrom. 121. No discussion shall take place in Parliament with respect to the conduct of any judge of the Supreme Court or of a High Court in the discharge of his duties except upon a motion for presenting an address to the President praying for the removal of the judge as hereinafter provided. 122. 1. The validity of any proceedings in Parliament shall not be called in question on the ground of any alleged irregularity of procedure. 2. No officer or member of Parliament in whom powers are vested by or under this Constitution for regulating procedure or the conduct of business, or for maintaining order, in Parliament shall be subject to the jurisdiction of any court in respect of the exercise by him of those powers. Chapter 3, Legislativep Nari of the P. Resident. 123. 1. If at any time, except when both Houses of Parliament are in session, the President is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances as the circumstances appear to him to require. Language to be used in Parliament. Restriction on discussion in Parliament. Courts not to inquire into proceedings of Parliament. Power of President to promulgate ordinances during recess of Parliament. Part 5, The Union, Arts. 119, 123. 2. An ordinance promulgated under this article shall have the same force and effect as an act of Parliament, but every such ordinance a. Shall be laid before both Houses of Parliament and shall cease to operate at the expiration of 6 weeks from the reassembly of Parliament, or, if before the expiration of that period resolutions disapproving it are passed by both Houses, upon the passing of the second of those resolutions, and b. May be withdrawn at any time by the President. Explanation: where the Houses of Parliament are summoned to reassemble on different dates, the period of 6 weeks shall be reckoned from the later of those dates for the purposes of this clause. 3. If and so far as an ordinance under this article makes any provision which Parliament would not under this Constitution be competent to enact, it shall be void. 1 Chapter 124. 1. There shall be a Supreme Court of India consisting of a Chief Justice of India and, until Parliament by law prescribes a larger number, of not more than 7 other judges. 2. Every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such of the judges of the Supreme Court and of the High Courts in the states as the President may deem necessary for the purpose, and shall hold office until he attains the age of 65 years. Provided that in the case of appointment of a judge other than the Chief Justice of India. Establishment and Constitution of Supreme Court. 1 Cl. 4. Was-ins. By the Constitution, 38th Amendment, Act, 1975, s. 2, retrospectively, and omitted by the Constitution, 44th Amendment, Act, 1978, s. 16, w. e. f. The 20th of June 1979. 2 Now, 25, Vide the Supreme Court, Number of Judges, Amendment Act, 1986, 22 of 1986, s. 2. Part 5, The Union, Arts. 123-124. Shall always be consulted, provided further that a judge may, by writing under his hand addressed to the President, resign his office. b. A judge may be removed from his office in the manner provided in Clause 4. 1. 2a. The age of a judge of the Supreme Court shall be determined by such authority and in such manner as Parliament may by law provide. 3. A person shall not be qualified for appointment as a judge of the Supreme Court unless he is a citizen of India and a. has been for at least 5 years a judge of a high court or of 2 or more such courts in succession, or b. has been for at least 10 years an advocate of a high court or of 2 or more such courts in succession, or C. Is, in the opinion of the President, a distinguished jurist. Explanation I. In this clause, High Court means a High Court which exercises, or which at any time before the commencement of this Constitution exercised, jurisdiction in any part of the territory of India. Explanation 2. In computing for the purpose of this clause the period during which a person has been an advocate, any period during which a person has held judicial office not inferior to that of a district judge after he became an advocate shall be included. 4. A judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address by each House of Parliament supported by a majority of the total membership of that House and by a majority of not less than 2/3 of the members of that House present and 1/4. By the Constitution, 15th Amendment, Act, 1963, S. 2. Part 5, the Union, Art. 124. Voting has been presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity. 5. Parliament may by law regulate the procedure for the presentation of an address and for the investigation and proof of the misbehavior or incapacity of a judge under Clause 4. 6. Every person appointed to be a judge of the Supreme Court shall, before he enters upon his office, make and subscribe before the President, or some person appointed in that behalf by him, an oath or affirmation according to the form set out for the purpose in the third schedule. 7. No person who has held office as a judge of the Supreme Court shall plead or act in any court or before any authority within the territory of India. 125. 1. There shall be paid to the judges of the Supreme Court such salaries as may be determined by Parliament by law and, until provision in that behalf is so made, such salaries as are specified in the second schedule. 2. Every judge shall be entitled to such privileges and allowances and to such rights in respect of leave of absence and pension as may from time to time be determined by or under law made by Parliament and, until so determined, to such privileges, allowances and rights as are specified in the second schedule. Provided that neither the privileges nor the allowances of a judge nor his rights in respect of leave of absence or pension shall be varied to his disadvantage after his appointment. 126. When the office of Chief Justice of India is vacant or when the Chief Justice is, by reason of absence or otherwise, unable to perform the duties of his office. 1 subs. By the Constitution, 54th Amendment, Act, 1986, S. 2, for CL. 1, W, E, F. The 4th of January 1986. Salaries, etc., of judges. Appointment of Acting Chief Justice. Part 5, the Union, Arts. 124, 126. The duties of the office shall be performed by such one of the other judges of the court as the President may appoint for the purpose. 127. 1. If at any time there should not be a quorum of the judges of the Supreme Court available to hold or continue any session of the court, the Chief Justice of India may, with the previous consent of the President and after consultation with the Chief Justice of the High Court concerned, request in writing the attendance at the sittings of the court, as an ad hoc judge, for such period as may be necessary, of a judge of a High Court duly qualified for appointment as a judge of the Supreme Court to be designated by the Chief Justice of India. 2. It shall be the duty of the judge who has been so designated, in priority to other duties of his office, to attend the sittings of the Supreme Court at the time and for the period for which his attendance is required, and while so attending he shall have all the jurisdiction, powers and privileges, and shall discharge the duties, of a judge of the Supreme Court. 128. Notwithstanding anything in this chapter, the Chief Justice of India may at any time, with the previous consent of the President, request any person who has held the office of a judge of the Supreme Court or of the Federal Court 1, or who has held the office of a judge of a High Court and is duly qualified for appointment as a judge of the Supreme Court to sit and act as a judge of the Supreme Court, and every such person so requested shall, while so sitting and acting, be entitled to such allowances as the President may by order determine and have all the jurisdiction, powers and privileges of, but shall not otherwise be deemed to be, a judge of that court. Provided that nothing in this article shall be deemed to require any such person as aforesaid to sit and act as a judge of that court unless he consents so to do. 1 ends. By the Constitution, 15th Amendment, Act, 1963, S. 3. Appointment of ad hoc judges. Attendance of retired judges at sittings of the Supreme Court. Part 5, The Union, Arts. 126, 128. 129. The Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. 130. The Supreme Court shall sit in Delhi or in such other place or places, as the Chief Justice of India may, with the approval of the President, from time to time, appoint. 131. Subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute. A. Between the Government of India and one or more states, or B. Between the Government of India and any state or states on one side and one or more other states on the other, or C. Between two or more states, if and in so far as the dispute involves any question, whether of law or fact, on which the existence or extent of a legal right depends. 1. Provided that the said jurisdiction shall not extend to a dispute arising out of any treaty, agreement, covenant, engagement, synod or other similar instrument which, having been entered into or executed before the commencement of this Constitution, continues in operation after such commencement, or which provides that the said jurisdiction shall not extend to such a dispute. 2. 131a. Exclusive jurisdiction of the Supreme Court in regard to questions as to constitutional validity of central laws. Representative. By the Constitution, 43rd Amendment, Act, 1977, S. 4 W. E. F. The 13th of April 1978. 132. 1. An appeal shall lie to the Supreme Court from any judgment, decree or final order of a high court in the territory of India, whether in a civil, criminal or Supreme Court to be a court of record. Seat of Supreme Court. Original. Jurisdiction of the Supreme Court. Appellate. Jurisdiction of Supreme Court in appeals from high courts in certain cases. 1 subs. By the Constitution, 7th Amendment, Act, 1956, S. 5 for the proviso. 2 ins. By the Constitution, 42nd Amendment, Act, 1976, S. 23, W. E. F. The 2nd of January 1977. Part 5, The Union, Arts. 129, 132. Other proceeding. 1. If the High Court certifies under Article 134a, that the case involves a substantial question of law as to the interpretation of this Constitution. 2 *******. 3. Where such a certificate is given, 3 ******, any party in the case may appeal to the Supreme Court on the ground that any such question as aforesaid has been wrongly decided. 3 *****. Explanation. For the purposes of this article, the expression, final order, includes an order deciding an issue which, if decided in favor of the appellant, would be sufficient for the final disposal of the case. 133. 4. 1. An appeal shall lie to the Supreme Court from any judgment, decree or final order in a civil proceeding of a high court in the territory of India. 5. If the High Court certifies under Article 134a, A. That the case involves a substantial question of law of general importance, and B. That in the opinion of the High Court the said question needs to be decided by the Supreme Court. 2. Notwithstanding anything in Article 132, any party appealing to the Supreme Court under Clause 1 may urge as one of the grounds in such appeal that a substantial question of law as to the interpretation of this Constitution has been wrongly decided. 3. Notwithstanding anything in this article, no appeal shall, unless Parliament by law otherwise provides, lie to the Supreme Court from the judgment, decree or final order of one judge of a high court. Appellate. Jurisdiction of Supreme Court in appeals from high courts in regard to civil matters. 1 subs. By the Constitution, 44th Amendment, Act, 1978, S. 17, 4. If the High Court certifies W. E. F. The 8th of January 1979. 2 CL. 2. Omitted by S. 17. Ibid. W. E. F. The 8th of January 1979. 3. Certain words omitted by S. 17. Ibid. W. E. F. The 8th of January 1979. 4 subs. By the Constitution, 30th Amendment, Act, 1972, S. 2. For CL. 1. W. E. F. The 27th of February 1973. 5 subs. By the Constitution, 44th Amendment, Act, 1978, S. 18. 4. If the High Court certifies W. E. F. The 8th of January 1979. Part 5. The Union, Arts. 132-133. 134. 1. An appeal shall lie to the Supreme Court from any judgment, final order or sentence in a criminal proceeding of a High Court in the Territory of India if the High Court a. has on appeal reversed an order of acquittal of an accused person and sentenced him to death, or b. has withdrawn for trial before itself any case from any court subordinate to its authority and has in such trial convicted the accused person and sentenced him to death, or c. 1. Certifies under Article 134a that the case is a fit one for appeal to the Supreme Court, provided that an appeal under subclause c. shall lie subject to such provisions as may be made in that behalf under Clause 1 of Article 145 and to such conditions as the High Court may establish or require. 2. Parliament may by law confer on the Supreme Court any further powers to entertain and hear appeals from any judgment, final order or sentence in a criminal proceeding of a High Court in the Territory of India subject to such conditions and limitations as may be specified in such law. 2. 134a. Every High Court, passing or making a judgment, decree, final order, or sentence, referred to in Clause 1 of Article 132 or Clause 1 of Article 133, or Clause 1 of Article 134. A. May, if it deems fit so to do, on its own motion, and b. shall, if an oral application is made, by or on behalf of the party aggrieved, immediately after the passing or making of such judgment, decree, final order or sentence. Determine, as soon as may be after such passing or making, the question whether a certificate of the nature. Appellate. Jurisdiction of Supreme Court in regard to criminal matters. Certificate for appeal to the Supreme Court. 1 subs. By the Constitution, 44th Amendment, Act, 1978, S. 19, 4, certifies. W. E. F. The 8th of January 1979. 2 ins. By S. 20, Ibid. W. E. F. The 8th of January 1979. Part 5, The Union, Arts. 134-134a. Referred to in Clause 1 of Article 132, or Clause 1 of Article 133 or, as the case may be, Subclause c. of Clause 1 of Article 134, may be given in respect of that case. 135. Until Parliament by law otherwise provides, the Supreme Court shall also have jurisdiction and powers with respect to any matter to which the provisions of Article 133 or Article 134 do not apply if jurisdiction and powers in relation to that matter were exercisable by the federal court immediately before the commencement of this Constitution under any existing law. 136. 1. Notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal in the Territory of India. 2. Nothing in Clause 1 shall apply to any judgment, determination, sentence or order passed or made by any court or tribunal constituted by or under any law relating to the armed forces. 137. Subject to the provisions of any law made by Parliament or any rules made under Article 145, the Supreme Court shall have power to review any judgment pronounced or order made by it. 138. 1. The Supreme Court shall have such further jurisdiction and powers with respect to any of the matters in the Union list as Parliament may by law confer. 2. The Supreme Court shall have such further jurisdiction and powers with respect to any matter as the Government of India and the Government of any state may by special agreement confer, if Parliament by law provides for the exercise of such jurisdiction and powers by the Supreme Court. 139. Parliament may by law confer on the Supreme Court power to issue directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, or any of them, for any purposes other than those mentioned in Clause 2 of Article 32. Jurisdiction and powers of the Federal Court. Under existing law to be exercisable by the Supreme Court. Special leave to appeal by the Supreme Court. Review of judgments or orders by the Supreme Court. Enlargement of the jurisdiction of the Supreme Court. Conferment on the Supreme Court of powers to issue certain writs. Part 5, the Union, Arts. 134a, 139. 1. 139a. 2. 1. Where cases involving the same or substantially the same questions of law are pending before the Supreme Court and one or more high courts, or before two or more high courts, and the Supreme Court is satisfied on its own motion or on an application made by the Attorney General of India or by a party to any such case that such questions are substantial questions of general importance, the Supreme Court may withdraw the case or cases pending before the High Court or the High Courts and dispose of all the cases itself, provided that the Supreme Court may, after determining the said questions of law, return any case so withdrawn together with a copy of its judgment on such questions to the High Court from which the case has been withdrawn, and the High Court shall on receipt thereof proceed to dispose of the case in conformity with such judgment. 2. The Supreme Court may, if it deems it expedient so to do for the ends of justice, transfer any case, appeal or other proceedings pending before any High Court to any other High Court. 140. Parliament may by law make provision for conferring upon the Supreme Court such supplemental powers not inconsistent with any of the provisions of this Constitution as may appear to be necessary or desirable for the purpose of enabling the Court more effectively to exercise the jurisdiction conferred upon it by or under this Constitution. 141. The law declared by the Supreme Court shall be binding on all courts within the territory of India. 142. 1. The Supreme Court in the exercise of its jurisdiction may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it, and any decree so passed or transfer of certain cases. Ancillary powers of Supreme Court. 1. Ins. By the Constitution, 42nd Amendment, Act, 1976, S. 24, W, E, F. The 2nd of January 1977. 2 subs. By the Constitution, 44th Amendment, Act, 1978, S. 21, for CL. 1, W, E, F. The 8th of January 1979. Law declared by Supreme Court to be binding on all courts. Enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. Part 5, the Union, Arts. 139a, 142. Orders so made shall be enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament, and, until provision in that behalf is so made, in such manner as the President may by order 1 prescribe. 2. Subject to the provisions of any law made in this behalf by Parliament, the Supreme Court shall, as respects the whole of the territory of India, have all and every power to make any order for the purpose of securing the attendance of any person, the discovery or production of any documents, or the investigation or punishment of any contempt of itself. 143. 1. If at any time it appears to the President that a question of law or fact has arisen, or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, he may refer the question to that court for consideration, and the court may, after such hearing as it thinks fit, report to the President its opinion thereon. 2. The President may, notwithstanding anything in 2*** the proviso to Article 131, refer a dispute of the kind mentioned in the 3, said proviso, to the Supreme Court for opinion, and the Supreme Court shall, after such hearing as it thinks fit, report to the President its opinion thereon. 144. All authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. 4. 144a. Special provisions as to disposal of questions relating to constitutional validity of laws, representative. By the Constitution, 43rd Amendment, Act, 1977, S. 5 W, E, F. The 13th of April 1978. Power of President to consult Supreme Court. Civil and judicial authorities to act in aid of the Supreme Court. 1. See the Supreme Court Decrees and Orders, Enforcement Order, 1954, c. 47. 2. The words, brackets and figures clause, I, of, omitted by the Constitution, 7th Amendment, Act, 1956, s. 29 and sch. 3 subs. By s. 29 and sch. Ibid. 4, said clause. 4 ins. By the Constitution, 42nd Amendment, Act, 1976, s. 25 W. E. F. The 2nd of January 1977. Part 5, The Union, Arts. 142, 144a. 145. 1. Subject to the provisions of any law made by Parliament, the Supreme Court may from time to time, with the approval of the President, make rules for regulating generally the practice and procedure of the court, including a. Rules as to the persons practicing before the court. b. Rules as to the procedure for hearing appeals and other matters pertaining to appeals, including the time within which appeals to the court are to be entered. c. Rules as to the proceedings in the court for the enforcement of any of the rights conferred by Part 3. 1. C. Rules as to the proceedings in the court under 2, Article 139a. d. Rules as to the entertainment of appeals under Subclause C of Clause 1 of Article 134. e. Rules as to the conditions subject to which any judgment pronounced or order made by the court may be reviewed and the procedure for such review, including the time within which applications to the court for such review are to be entered. F. Rules as to the costs of and incidental to any proceedings in the court and as to the fees to be charged in respect of proceedings therein. G. Rules as to the granting of bail. H. Rules as to stay of proceedings. I. Rules providing for the summary determination of any appeal which appears to the court to be frivolous or vexatious or brought for the purpose of delay. J. Rules as to the procedure for inquiries referred to in Clause 1 of Article 317. Rules of court, etc. 1 ins. By the Constitution, 42nd Amendment, Act, 1976, s. 26 W. E. F. The 2nd of January 1977. 2 subs. By the Constitution, 43rd Amendment, Act, 1977, s. 6 4, Articles 131a and 139a W. E. F. The 13th of April 1978. Part 5, The Union, Art. 145. 2. Subject to the 1. Provisions of 2 Clause 3. Rules made under this article may fix the minimum number of judges who are to sit for any purpose, and may provide for the powers of single judges and division courts. 2 The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this Constitution or for the purpose of hearing any reference under Article 143 shall be 5. Provided that, where the court hearing an appeal under any of the provisions of this chapter other than Article 132 consists of less than 5 judges, and in the course of the hearing of the appeal the court is satisfied that the appeal involves a substantial question of law as to the interpretation of this Constitution, the determination of which is necessary for the disposal of the appeal, such court shall refer the question for opinion to a court constituted as required by this clause for the purpose of deciding any case involving such a question, and shall on receipt of the opinion dispose of the appeal in conformity with such opinion. 4. No judgment shall be delivered by the Supreme Court save in open court, and no report shall be made under Article 143 save in accordance with an opinion also delivered in open court. 5. No judgment and no such opinion shall be delivered by the Supreme Court save with the concurrence of a majority of the judges present at the hearing of the case, but nothing in this clause shall be deemed to prevent a judge who does not concur from delivering a dissenting judgment or opinion. 146. 1. Appointments of officers and servants of the Supreme Court shall be made by the Chief Justice of India or such other judge or officer of the court as he may direct. 1 subs. By the Constitution, 42nd Amendment, Act, 1976, s. 26, for provisions of Clause 3, W. E. F. The 2nd of January 1977. 2. Certain words omitted by the Constitution, 43rd Amendment, Act, 1977, s. 6. W. E. F. the 13th of April 1978. 3 subs. By the Constitution, 42nd Amendment, Act, 1976, S. 26, 4, the minimum number, W.E.F. the 2nd of January 1977. Officers and servants and the expenses of the Supreme Court. Part 5, the Union, Arts. 145-146. Provided that the President may by rule require that in such cases as may be specified in the rule, no person not already attached to the court shall be appointed to any office connected with the court, save after consultation with the Union Public Service Commission. 2. Subject to the provisions of any law made by Parliament, the conditions of service of officers and servants of the Supreme Court shall be such as may be prescribed by rules made by the Chief Justice of India or by some other judge or officer of the court authorized by the Chief Justice of India to make rules for the purpose. Provided that the rules made under this clause shall, so far as they relate to salaries, allowances, leave or pensions, require the approval of the President. 3. The administrative expenses of the Supreme Court, including all salaries, allowances and pensions payable to or in respect of the officers and servants of the court, shall be charged upon the Consolidated Fund of India, and any fees or other monies taken by the court shall form part of that fund. 147. In this chapter and in Chapter 5 of Part 6, references to any substantial question of law as to the interpretation of this Constitution shall be construed as including references to any substantial question of law as to the interpretation of the Government of India Act, 1935, including any enactment amending or supplementing that Act, or of any order in council or order made thereunder, or of the Indian Independence Act, 1947, or of any order made thereunder. CHAPTERB, COMPTROLLER and AUDITORGENERAL of INDIA. 148. 1. There shall be a Controller and Auditor General of India who shall be appointed by the President by warrant under his hand and seal and shall only be removed from office in like manner and on the like grounds as a judge of the Supreme Court. Interpretation. Controller and Auditor General of India. Part 5, the Union, Arts. 146-148. 2. Every person appointed to be the Controller and Auditor General of India shall, before he enters upon his office, make and subscribe before the President, or some person appointed in that behalf by him, an oath or affirmation according to the form set out for the purpose in the third schedule. 3. The salary and other conditions of service of the Controller and Auditor General shall be such as may be determined by Parliament by law and, until they are so determined, shall be as specified in the second schedule. Provided that neither the salary of a Controller and Auditor General nor his rights in respect of leave of absence, pension or age of retirement shall be varied to his disadvantage after his appointment. 4. The Controller and Auditor General shall not be eligible for further office either under the Government of India or under the government of any state after he has ceased to hold his office. 5. Subject to the provisions of this Constitution and of any law made by Parliament, the conditions of service of persons serving in the Indian Audit and Accounts Department and the administrative powers of the Controller and Auditor General shall be such as may be prescribed by rules made by the President after consultation with the Controller and Auditor General. 6. The administrative expenses of the office of the Controller and Auditor General, including all salaries, allowances and pensions payable to or in respect of the persons serving in that office, shall be charged upon the Consolidated Fund of India. 149. The Controller and Auditor General shall perform such duties and exercise such powers in relation to the accounts of the Union and of the States and of any other authority or body as may be prescribed by or under any law made by Parliament and, until provision in that behalf is so made, shall perform such duties and exercise such powers in relation to the accounts of the Union and duties and powers of the Controller and Auditor General. Part 5, the Union, Arts. 148-149. Of the states as were conferred on or exercisable by the Auditor General of India immediately before the commencement of this Constitution in relation to the accounts of the Dominion of India and of the provinces respectively. 1. 150. The accounts of the Union and of the states shall be kept in such form as the President may, 2, on the advice of the Controller and Auditor General of India, prescribe. 151. 1. The reports of the Comptroller and Auditor General of India relating to the accounts of the Union shall be submitted to the President, who shall cause them to be laid before each House of Parliament. 2. The reports of the Comptroller and Auditor General of India relating to the accounts of a state shall be submitted to the Governor 3*** of the state, who shall cause them to be laid before the legislature of the state. 1 subs. By the Constitution, 42nd Amendment, Act, 1976, S. 27, for Art. 150. W. E. F. The 4th of January 1977. 2 subs. By the Constitution, 44th Amendment, Act, 1978, S. 22, for, after. Consultation with W. E. F. The 20th of June 1979. 3. The words, or Raj Pramukh, omitted by the Constitution, 7th Amendment, Act, 1956, S. 29 and SCH. Form of accounts of the Union and of the states. Audit reports. Part 5, The Union, Arts. 149, 151. Part 6. The states 1******, CHAPTERI, GENERAL. 152. In this part, unless the context otherwise requires, the expression, State 2, does not include the state of Jammu and Kashmir. CHAPTER2, TEXECUTIVE. The Governor 153. There shall be a governor for each state 3, provided that nothing in this article shall prevent the appointment of the same person as governor for 2 or more states. 154. 1. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution. 2. Nothing in this article shall a. Be deemed to transfer to the governor any functions conferred by any existing law on any other authority, or b. Prevent Parliament or the legislature of the state from conferring by law functions on any authority subordinate to the governor. 155. The governor of a state shall be appointed by the President by warrant under his hand and seal. 156. 1. The governor shall hold office during the pleasure of the President. Definition. 76. Governors of states. Executive power of state. Appointment of governor. Term of office of governor. 1. The words, in Part A of the first schedule, omitted by the Constitution. 7th Amendment, Act, 1956, S. 29 and SCH. 2 subs. By S. 29 and SCH, ibid, for, means a state specified in Part A of the first schedule. 3 added by S. 6, ibid. 2. The governor may, by writing under his hand addressed to the President, resign his office. 3. Subject to the foregoing provisions of this article, a governor shall hold office for a term of 5 years from the date on which he enters upon his office, provided that a governor shall, notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. 157. No person shall be eligible for appointment as governor unless he is a citizen of India and has completed the age of 35 years. 158. 1. The governor shall not be a member of either House of Parliament or of a House of the Legislature of any state specified in the first schedule, and if a member of either House of Parliament or of a House of the Legislature of any such state be appointed governor, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as governor. 2. The governor shall not hold any other office of profit. 3. The governor shall be entitled without payment of rent to the use of his official residences and shall be also entitled to such emoluments, allowances and privileges as may be determined by Parliament by law and, until provision in that behalf is so made, such emoluments, allowances and privileges as are specified in the second schedule. 1.3a, where the same person is appointed as governor of 2 or more states, the emoluments and allowances payable to the governor shall be allocated among the states in such proportion as the President may by order determine. 4. The emoluments and allowances of the governor shall not be diminished during his term of office. 159. Every governor and every person discharging the functions of the governor shall, before entering upon his office, make and subscribe in the presence of the Chief Justice of the High Court exercising jurisdiction in relation to the state, or, in his absence, the seniormost. Qualifications for appointment as governor. Conditions of governor's office. Oath or affirmation by the governor. 1. Ins. By the Constitution, 7th Amendment, Act, 1956, S. 7. Part 6, the States, Arts. 156, 159. Judge of that court available, an oath or affirmation in the following form, that is to say, I, A, B, do swear in the name of God that I will faithfully execute the office of governor, or discharge the functions of the governor, of name of the state, and will to the best of my ability preserve, protect and defend the Constitution and the law, and that I will devote myself to the service and well-being of the people of name of the state. 160. The President may make such provision as he thinks fit for the discharge of the functions of the governor of a state in any contingency not provided for in this chapter. 161. The governor of a state shall have the power to grant pardons, reprieves, respites or remissions of punishment, or to suspend, remit or commute the sentence of any person convicted of any offense against any law relating to a matter to which the executive power of the state extends. 162. Subject to the provisions of this Constitution, the executive power of a state shall extend to the matters with respect to which the legislature of the state has power to make laws. Provided that in any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to, and limited by, the executive power expressly conferred by this Constitution or by any law made by Parliament upon the Union or authorities thereof. Council of Ministers. 163. 1. There shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his functions, except in so far as he is by or under this Constitution required to exercise his functions or any of them in his discretion. 2. If any question arises whether any matter is or is not a matter as respects which the governor is by or under this Constitution required to act in his discretion, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion. Solemnly affirm. Discharge of the functions of the governor in certain contingencies. Power of governor to grant pardons, etc., and to suspend, remit or commute sentences in certain cases. Extent of executive power of state. Council of Ministers to aid and advise. Governor. Part 6, the States, Arts. 159, 163. 3. The question whether any, and if so what, advice was tendered by ministers to the governor shall not be inquired into in any court. 164. 1. The chief minister shall be appointed by the governor and the other ministers shall be appointed by the governor on the advice of the chief minister, and the ministers shall hold office during the pleasure of the governor. Provided that in the states of 1. Chhattisgarh, Jharkhand, Madhya Pradesh and Orissa, there shall be a minister in charge of tribal welfare who may in addition be in charge of the welfare of the scheduled castes and backward classes or any other work. 2. 1a. The total number of ministers, including the chief minister, in the Council of Ministers in a state shall not exceed 15% of the total number of members of the Legislative Assembly of that state. Provided that the number of ministers, including the chief minister in a state shall not be less than 12. Provided further that where the total number of ministers including the chief minister in the Council of Ministers in any state at the commencement of the Constitution, 91st Amendment, Act, 2003 exceeds the said 15%, or the number specified in the first proviso, as the case may be, then the total number of ministers in that state shall be brought in conformity with the provisions of this clause within 6 months from such date *, as the President may by public notification appoint. 1b. A member of the Legislative Assembly of a state or either house of the legislature of a state having legislative counsel belonging to any political party who is disqualified for being a member of that house under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as a minister under clause 1 for duration of the period commencing from the date of his disqualification till the date on which the term of his office as such member would expire or where he contests any election to the Legislative Assembly of a state or either house of the legislature of a state having legislative counsel, as the case may be, before the expiry of such period, till the date on which he is declared elected, whichever is earlier. Other provisions as to ministers. 1 subs. By the Constitution, 94th Amendment, Act 2006, S. 2, 4, Bihar. 2 ins. By the Constitution, 91st Amendment, Act 2003, S. 3. Asterisk the 1st of July 2004, by the SO. 21, dated the 1st of July 2004. Part 6, the States, Arts. 163-164. 2. The Council of Ministers shall be collectively responsible to the Legislative Assembly of the state. 3. Before a minister enters upon his office, the governor shall administer to him the oaths of office and of secrecy according to the forms set out for the purpose in the third schedule. 4. A minister who for any period of 6 consecutive months is not a member of the legislature of the state shall at the expiration of that period cease to be a minister. 5. The salaries and allowances of ministers shall be such as the legislature of the state may from time to time by law determine and, until the legislature of the state so determines, shall be as specified in the second schedule. The Advocate General for the state. 165. 1. The governor of each state shall appoint a person who is qualified to be appointed a judge of a high court to be Advocate General for the state. 2. It shall be the duty of the Advocate General to give advice to the government of the state upon such legal matters, and to perform such other duties of a legal character, as may from time to time be referred or assigned to him by the governor, and to discharge the functions conferred on him by or under this Constitution or any other law for the time being in force. 3. The Advocate General shall hold office during the pleasure of the governor, and shall receive such remuneration as the governor may determine. Conduct of Government Business 166. 1. All executive action of the government of a state shall be expressed to be taken in the name of the governor. 2. Orders and other instruments made and executed in the name of the governor shall be authenticated in such manner as may be specified in rules to be made by the governor, and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the governor. Advocate General for the state. Conduct of business of the government of a state. Part 6, the States, Arts. 164-166. 3. The governor shall make rules for the more convenient transaction of the business of the government of the state, and for the allocation among ministers of the said business in so far as it is not business with respect to which the governor is by or under this Constitution required to act in his discretion. 1*******. 167. It shall be the duty of the chief minister of each state, a. To communicate to the governor of the state all decisions of the council of ministers relating to the administration of the affairs of the state and proposals for legislation. B. To furnish such information relating to the administration of the affairs of the state and proposals for legislation as the governor may call for, and c. If the governor so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Chapter 3, Tes Tate Legislature. General 168. 1. For every state there shall be a legislature which shall consist of the governor, and a. In the states of 2, Andhra Pradesh, Bihar, 3*****4, Madhya Pradesh, 5****6, Maharashtra, 7, Karnataka, 8****9, and Uttar Pradesh, 2 houses. B. In other states, 1 house. Duties of Chief Minister as respects the furnishing of information to governor, etc. Constitution of legislatures in states. 1 CL. 4. Was-ins. By the Constitution, 42nd Amendment, Act, 1976, S. 28 W. E. F. The 1st of March 1977, and omitted by the Constitution, 44th Amendment, Act, 1978, S. 23 W. E. F. The 20th of June 1979. 2-ins. By the Andhra Pradesh Legislative Council Act, 2005, 1 of 2006, S. 3 W. E. F. The 30th of March 2007. 3. The word Bombay, omitted by the Bombay Reorganization Act, 1960, 11 of 1960. S. 20 W. E. F. The 5th of January 1960. 4. No date has been appointed under S. 8(2) of the Constitution, 7th Amendment. Act, 1956, for the insertion of the words Madhya Pradesh in this sub-clause. 5. The words Tamil Nadu, omitted by Tamil Nadu Legislative Council, Abolition, Act. 1986, 40 of 1986, S. 4 W. E. F. The 11th of January 1986. 6-ins. By the Bombay Reorganization Act, 1960, 11 of 1960, S. 20 W. E. F. The 5th of January 1960. 7 subs. By the Mysore State Alteration of Name Act, 1973, 31 of 1973, S. 4 Mysore, W. E. F. The 11th of January 1973, which was inserted by the Constitution, 7th Amendment, Act, 1956, S. 8(1). 8. The word Punjab, omitted by the Punjab Legislative Council, Abolition, Act, 1969. 46 of 1969, S. 4 W. E. F. The 1st of July 1970. 9 subs. By the West Bengal Legislative Council, Abolition, Act, 1969, 20 of 1969, S. 4 Uttar Pradesh and West Bengal, W. E. F. The 8th of January 1969. Part 6, the States, Arts. 166, 168. 2. Where there are 2 houses of the legislature of a state, one shall be known as the Legislative Council and the other as the Legislative Assembly, and where there is only one house, it shall be known as the Legislative Assembly. 169. 1. Notwithstanding anything in Article 168, Parliament may by law provide for the abolition of the Legislative Council of a state having such a council or for the creation of such a council in a state having no such council, if the Legislative Assembly of the state passes a resolution to that effect by a majority of the total membership of the Assembly and by a majority of not less than 2/3 of the members of the Assembly present and voting. 2. Any law referred to in Clause 1 shall contain such provisions for the amendment of this Constitution as may be necessary to give effect to the provisions of the law and may also contain such supplemental, incidental and consequential provisions as Parliament may deem necessary. 3. No such law as aforesaid shall be deemed to be an amendment of this Constitution for the purposes of Article 368. 1. 170. 1. Subject to the provisions of Article 333, the Legislative Assembly of each state shall consist of not more than 500, and not less than 60, members chosen by direct election from territorial constituencies in the state. 2. For the purposes of Clause 1, each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it shall, so far as practicable, be the same throughout the state. 2. Explanation. In this clause, the expression, population, means the population as ascertained at the last preceding census of which the relevant figures have been published. Abolition or creation of legislative councils in states. 1 subs. By the Constitution, 7th Amendment, Act, 1956, S. 9, for Art. 170. 2 subs. By the Constitution, 42nd Amendment, Act, 1976, S. 29, for the explanation, W. E. F. The 1st of March 1977. Composition of the Legislative Assemblies. Part 6, the States, Arts. 168, 170. provided that the reference in this explanation to the last preceding census of which the relevant figures have been published shall, until the relevant figures for the first census taken after the year 1, 2026, have been published, be construed as a reference to the 2001 census. 3. Upon the completion of each census, the total number of seats in the Legislative Assembly of each state and the division of each state into territorial constituencies shall be readjusted by such authority and in such manner as Parliament may by law determine, provided that such readjustment shall not affect representation in the Legislative Assembly until the dissolution of the then existing Assembly. 3. Provided further that such readjustment shall take effect from such date as the President may, by order, specify, and until such readjustment takes effect, any election to the Legislative Assembly may be held on the basis of the territorial constituencies existing before such readjustment. Provided also that until the relevant figures for the first census taken after the year 1, 2026, have been published, it shall not be necessary to readjust. I. The total number of seats in the Legislative Assembly of each state is readjusted on the basis of the 1971 census, and E. The division of such state into territorial constituencies as may be readjusted on the basis of the 2001 census. Under this clause. 171. 1. The total number of members in the Legislative Council of a state having such a council shall not exceed 1/3 of the total number of members in the Legislative Assembly of that state. Provided that the total number of members in the Legislative Council of a state shall in no case be less than 40. 1 subs. By the Constitution, 84th Amendment, Act 2001, S. 5/4/2000, and 1971, respectively. 2 subs. By the Constitution, 87th Amendment, Act 2003, S. 4/4/1991. 3 ins. By the Constitution, 42nd Amendment, Act 1976, S. 29, W. E. F. The 1st of March 1977. 4 subs. By the Constitution, 84th Amendment, Act 2001, S. 5 for certain words. 5 subs. By the Constitution, 7th Amendment, Act 1956, S. 10 for 1/4. Composition of the Legislative Councils. Part 6. The States, Arts. 170-171. 2. Until Parliament by law otherwise provides, the composition of the Legislative Council of a state shall be as provided in Clause 3. 3. Of the total number of members of the Legislative Council of a state. A. As nearly as may be, 1/3 shall be elected by electorates consisting of members of municipalities, district boards and such other local authorities in the state as Parliament may by law specify. B. As nearly as may be, 1/12 shall be elected by electorates consisting of persons residing in the state who have been for at least 3 years graduates of any university in the territory of India or have been for at least 3 years in possession of qualifications prescribed by or under any law made by Parliament as equivalent to that of a graduate of any such university. C. As nearly as may be, 1/12 shall be elected by electorates consisting of persons who have been for at least 3 years engaged in teaching in such educational institutions within the state, not lower in standard than that of a secondary school, as may be prescribed by or under any law made by Parliament. D. As nearly as may be, 1/3 shall be elected by the members of the Legislative Assembly of the state from amongst persons who are not members of the Assembly. E. The remainder shall be nominated by the Governor in accordance with the provisions of Clause 5. 4. The members to be elected under subclauses A, B, and C of Clause 3 shall be chosen in such territorial constituencies as may be prescribed by or under any law made by Parliament, and the elections under the said subclauses and under subclause D of the said clause shall be held in accordance with the system of proportional representation by means of the single transferable vote. 5. The members to be nominated by the Governor under subclause E of Clause 3 shall consist of persons. Part 6. The States, Art. 171. Having special knowledge or practical experience in respect of such matters as the following, namely: literature, science, art, cooperative movement and social service. 172. 1. Every legislative assembly of every state, unless sooner dissolved, shall continue for 5 years from the date appointed for its first meeting and no longer, and the expiration of the said period of 5 years shall operate as a dissolution of the assembly, provided that the said period may, while a proclamation of emergency is in operation, be extended by Parliament by law for a period not exceeding 1 year at a time and not extending in any case beyond a period of 6 months after the proclamation has ceased to operate. 2. The Legislative Council of a state shall not be subject to dissolution, but as nearly as possible 1/3 of the members thereof shall retire as soon as may be on the expiration of every second year in accordance with the provisions made in that behalf by Parliament by law. 173. A person shall not be qualified to be chosen to fill a seat in the legislature of a state unless he 2a. Is a citizen of India, and makes and subscribes before some person authorized in that behalf by the Election Commission an oath or affirmation according to the form set out for the purpose in the third schedule. B. Is, in the case of a seat in the Legislative Assembly, not less than 25 years of age, and, in the case of a seat in the Legislative Council, not less than 30 years of age, and C. Possesses such other qualifications as may be prescribed in that behalf by or under any law made by Parliament. Duration of state legislatures. Qualification for membership of the state legislature. 1 subs. By the Constitution, 44th Amendment, Act, 1978, S. 24, for 6 years W, E, F. The 9th of June 1979. The words, 6 years, were subs. For the original words 5 years by the Constitution, 42nd Amendment, Act, 1976, S. 30, W, E, F. The 1st of March 1977. 2 subs. By the Constitution, 16th Amendment, Act, 1963, S. 4, for CL. A. Part 6, the States, Arts. 171, 173. 174. 1. The Governor shall from time to time summon the House or each House of the Legislature of the state to meet at such time and place as he thinks fit, but 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. 2. The Governor may from time to time, A. prorogue the House or either House, B. dissolve the Legislative Assembly. 175. 1. The Governor may address the Legislative Assembly or, in the case of a state having a Legislative Council, either House of the Legislature of the state, or both Houses assembled together, and may for that purpose require the attendance of members. 2. The Governor may send messages to the House or Houses of the Legislature of the state, whether with respect to a bill then pending in the Legislature or otherwise, and a House to which any message is so sent shall with all convenient dispatch consider any matter required by the message to be taken into consideration. 176. 1. At the commencement of 2. The first session after each general election to the Legislative Assembly and at the commencement of the first session of each year, the Governor shall address the Legislative Assembly or, in the case of a state having a Legislative Council, both Houses assembled together and inform the Legislature of the causes of its summons. 2. Provision shall be made by the rules regulating the procedure of the House or either House for the allotment of time for discussion of the matters referred to in such address. 3 ****. 177. Every minister and the Advocate General for a state shall have the right to speak in, and otherwise to take part in the proceedings of, the Legislative Assembly of the state or, in the case of a state having a legislative sessions of the state legislature, prorogation and dissolution. Right of Governor to address and send messages to the House or Houses. Special address by the Governor. 1 subs. By the Constitution, First Amendment, Act, 1951, S. 8 for Art. 174. 2 subs. By S. 9, Ibid. For every session. 3. The words, and for the precedence of such discussion over other business of the House, omitted by S. 9, Ibid. Rights of Ministers and Advocate General as respects the Houses. Part 6, the States, Arts. 174, 177. Counsel, both Houses, and to speak in, and otherwise to take part in the proceedings of, any committee of the legislature of which he may be named a member, but shall not, by virtue of this article, be entitled to vote. Officers of the state legislature. 178. Every legislative assembly of a state shall, as soon as may be, choose 2 members of the assembly to be respectively Speaker and Deputy Speaker thereof, and, so often as the office of Speaker or Deputy Speaker becomes vacant, the assembly shall choose another member to be Speaker or Deputy Speaker, as the case may be. 179. A member holding office as Speaker or Deputy Speaker of an assembly. A. Shall vacate his office if he ceases to be a member of the assembly. B. May at any time by writing under his hand addressed, if such member is the Speaker, to the Deputy Speaker, and if such member is the Deputy Speaker, to the Speaker, resign his office, and C. May be removed from his office by a resolution of the Assembly passed by a majority of all the then members of the Assembly. Provided that no resolution for the purpose of Clause C shall be moved unless at least 14 days' notice has been given of the intention to move the resolution. Provided further that, whenever the Assembly is dissolved, the Speaker shall not vacate his office until immediately before the first meeting of the Assembly after the dissolution. 180. 1. While the office of Speaker is vacant, the duties of the office shall be performed by the Deputy Speaker, or, if the office of Deputy Speaker is also vacant, by such member of the Assembly as the Governor may appoint for the purpose. The Speaker and Deputy Speaker of the Legislative Assembly. Vacation and resignation of, and removal from, the offices of Speaker and Deputy Speaker. Power of the Deputy Speaker or other person to perform the duties of the office of, or to act as, Speaker. Part 6, the States, Arts. 177, 180. 2. During the absence of the Speaker from any sitting of the Assembly, the Deputy Speaker, or, if he is also absent, such person as may be determined by the rules of procedure of the Assembly, or, if no such person is present, such other person as may be determined by the Assembly, shall act as Speaker. 181. 1. At any sitting of the Legislative Assembly, while any resolution for the removal of the Speaker from his office is under consideration, the Speaker, or while any resolution for the removal of the Deputy Speaker from his office is under consideration, the Deputy Speaker shall not, though he is present, preside, and the provisions of Clause 2 of Article 180 shall apply in relation to every such sitting as they apply in relation to a sitting from which the Speaker, or, as the case may be, the Deputy Speaker is absent. 2. The Speaker shall have the right to speak in, and otherwise to take part in the proceedings of, the Legislative Assembly while any resolution for his removal from office is under consideration in the Assembly, and shall, notwithstanding anything in Article 189, be entitled to vote only in the first instance on such resolution or on any other matter during such proceedings, but not in the case of an equality of votes. 182. The Legislative Council of every state having such council shall, as soon as may be, choose 2 members of the council to be respectively chairman and deputy chairman thereof, and, so often as the office of chairman or deputy chairman becomes vacant, the council shall choose another member to be chairman or deputy chairman, as the case may be. 183. A member holding office as chairman or deputy chairman of a legislative council. A. Shall vacate his office if he ceases to be a member of the council. B. May at any time by writing under his hand addressed, if such member is the chairman, to the Speaker or the Deputy Speaker not to preside while a resolution for his removal from office is under consideration. The Chairman and Deputy Chairman of the Legislative Council. Vacation and resignation of, and removal from, the offices of Chairman and Deputy Chairman. Part 6, the States, Arts. 180, 183. Deputy Chairman, and if such member is the Deputy Chairman, to the Chairman, resign his office, and C. May be removed from his office by a resolution of the Council passed by a majority of all the then members of the Council. Provided that no resolution for the purpose of Clause C shall be moved unless at least 14 days' notice has been given of the intention to move the resolution. 184. 1. While the office of chairman is vacant, the duties of the office shall be performed by the deputy chairman, or, if the office of deputy chairman is also vacant, by such member of the council as the governor may appoint for the purpose. 2. During the absence of the chairman from any sitting of the council, the deputy chairman, or, if he is also absent, such person as may be determined by the rules of procedure of the council, or, if no such person is present, such other person as may be determined by the council, shall act as chairman. 185. 1. At any sitting of the Legislative Council, while any resolution for the removal of the chairman from his office is under consideration, the chairman, or while any resolution for the removal of the deputy chairman from his office is under consideration, the deputy chairman shall not, though he is present, preside, and the provisions of Clause 2 of Article 184 shall apply in relation to every such sitting as they apply in relation to a sitting from which the chairman or, as the case may be, the deputy chairman is absent. 2. The chairman shall have the right to speak in, and otherwise to take part in the proceedings of, the Legislative Council while any resolution for his removal from office is under consideration in the Council, and shall, notwithstanding anything in Article 189, be entitled to vote only in the first instance on such resolution or on any other matter during such proceedings, but not in the case of an equality of votes. Power of the deputy chairman or other person to perform the duties of the office of, or to act as chairman. The chairman or the deputy chairman not to preside while a resolution for his removal from office is under consideration. Part 6. The States, Arts. 183, 185. 186. There shall be paid to the Speaker and the Deputy Speaker of the Legislative Assembly, and to the Chairman and the Deputy Chairman of the Legislative Council, such salaries and allowances as may be respectively fixed by the Legislature of the State by law, and, until provision in that behalf is so made, such salaries and allowances as are specified in the second schedule. 187. 1. The House or each House of the Legislature of a State shall have a separate secretarial staff, provided that nothing in this clause shall, in the case of the legislature of a state having a legislative council, be construed as preventing the creation of posts common to both houses of such legislature. 2. The legislature of a state may by law regulate the recruitment and the conditions of service of persons appointed to the secretarial staff of the House or houses of the legislature of the state. 3. Until provision is made by the legislature of the state under Clause 2, the governor may, after consultation with the Speaker of the Legislative Assembly or the Chairman of the Legislative Council, as the case may be, make rules regulating the recruitment and the conditions of service of persons appointed to the secretarial staff of the Assembly or the Council, and any rules so made shall have effect subject to the provisions of any law made under the said clause. Conduct of Business. 188. Every member of the Legislative Assembly or the Legislative Council of a state shall, before taking his seat, make and subscribe before the governor, or some person appointed in that behalf by him, an oath or affirmation according to the form set out for the purpose in the third schedule. 189. 1. Save as otherwise provided in this Constitution, all questions at any sitting of a House of the Legislature of a state shall be determined by a majority of votes of the members present and voting, other than the Speaker or Chairman, or person acting as such. Salaries and allowances of the Speaker and Deputy Speaker and the Chairman and Deputy Chairman. Secretariat of State Legislature. Oath or affirmation by members. Voting in Houses. Power of Houses to act, notwithstanding vacancies and quorum. Part 6. The States, Arts. 186, 189. The Speaker or Chairman, or person acting as such, shall not vote in the first instance, but shall have and exercise a casting vote in the case of an equality of votes. 2. A House of the Legislature of a state shall have power to act notwithstanding any vacancy in the membership thereof, and any proceedings in the legislature of a state shall be valid notwithstanding that it is discovered subsequently that some person who was not entitled so to do sat or voted or otherwise took part in the proceedings. 3. Until the legislature of the state by law otherwise provides, the quorum to constitute a meeting of a House of the legislature of a state shall be 10 members or 1/10 of the total number of members of the House, whichever is greater. 4. If at any time during a meeting of the Legislative Assembly or the Legislative Council of a state there is no quorum, it shall be the duty of the Speaker or Chairman, or person acting as such, either to adjourn the House or to suspend the meeting until there is a quorum. Disqualifications of members. 190. 1. No person shall be a member of both houses of the legislature of a state, and provision shall be made by the legislature of the state by law for the vacation by a person who is chosen a member of both houses of his seat in one house or the other. 2. No person shall be a member of the legislatures of two or more states specified in the first schedule, and if a person is chosen a member of the legislatures of two or more such states, then, at the expiration of such period as may be specified in Rules 1 made by the President, that person's seat in the legislatures of all such states shall become vacant, unless he has previously resigned his seat in the legislatures of all but one of the states. 3. If a member of a house of the legislature of a state. 1. See the Prohibition of Simultaneous Membership Rules, 1950, published with the Ministry of Law Notification No. F. 46/50th C., dated the 26th of January 1950, Gazette of India, Extraordinary, p. 678. Vacation of seats. Part 6, The States, Parts 189, 190. A. Becomes subject to any of the disqualifications mentioned in 1, Clause 1, or Clause 2, of Article 191, or 2. B. Resigns his seat by writing under his hand address to the Speaker or the Chairman, as the case may be, and his resignation is accepted by the Speaker or the Chairman, as the case may be. His seat shall thereupon become vacant. 3. Provided that in the case of any resignation referred to in subclause B, if from information received or otherwise and after making such inquiry as he thinks fit, the Speaker or the Chairman, as the case may be, is satisfied that such resignation is not voluntary or genuine, he shall not accept such resignation. 4. If for a period of 60 days a member of a house of the legislature of a state is without permission of the House absent from all meetings thereof, the House may declare his seat vacant. Provided that in computing the said period of 60 days no account shall be taken of any period during which the House is prorogued or is adjourned for more than 4 consecutive days. 191. 1. A person shall be disqualified for being chosen as, and for being, a member of the Legislative Assembly or Legislative Council of a state. A. If he holds any office of profit under the Government of India or the Government of any state specified in the first schedule, other than an office declared by the legislature of the state by law not to disqualify its holder. B. If he is of unsound mind and stands so declared by a competent court. 1 subs. By the Constitution, 52nd Amendment, Act, 1985, S. 4. Clause 1, of Article 191, W, E, F. The 3rd of January 1985. 2 subs. By the Constitution, 33rd Amendment, Act, 1974, S. 3. For subclause B. 3 ins. By S. 3, Ibid. Disqualifications for membership. Part 6, The States, Parts 190-191. C. If he is an undischarged insolvent. D. If he is not a citizen of India, or has voluntarily acquired the citizenship of a foreign state, or is under any acknowledgement of allegiance or adherence to a foreign state. E. If he is so disqualified by or under any law made by Parliament.